that are supplemented by state funds, state grants, as well as federal funding.
And where does the money come from?
Well, in each instance, it comes from state appropriations and also federal grant programs.
And does your office have to apply for them with the federal government?
I believe so. There might be one or two instances where there are statutory grants under the federal statutes, but I think most of them are application-based.
And you were responsible for applying for those grants, true?
No, sir. The grants division of the office was responsible for applying.
But you were overseeing them?
No, sir. That's a division that reported to Lacey Mays.
Okay. As part of the Office of General Counsel, or by October 2020, what was your title at the agency?
Deputy for Legal Counsel.
Okay. And so you're giving isn't it true that you gave the Office of the Attorney General legal advice about those grants?
Yes.
Okay. I think I'm over the target now, finally. So my understanding is, correct me if I'm wrong, in October 2020, after you had so-called blown the whistle with your friends, you were still providing legal advice to the Office of Attorney General about grant applications to the federal government, yes?
Yes, sir.
And one of the reservations that you expressed was that the Office of the Attorney General might have some problems applying for federal grants because Ken Paxton was under indictment. True?
That was an issue that came to my mind. Yes, sir.
He was under indictment the whole time you worked there, right?
I'm not sure when it occurred, but I believe that's probably true.
And every other year before October of 2020, you didn't provide that advice to the Office of the Attorney General, true?
That's right.
And in fact, if Ken Paxton was not allowed to sign those grant applications, it might have cost the Attorney General's office between $1 and $10 million in federal money. True?
I don't know the specific numbers, but yes, if we were prohibited as an agency from participating in the federal grant program because of an ongoing indictment or conviction for felony that was prohibited under those federal programs, and it could cost the agency.
So after you blew the whistle on September 30th of 2020, your advice about those grants changed, right?
No, sir.
You were advising the Attorney General's office about this all the way on from before that?
No. What you asked is, did my advice change? The answer is no. I didn't provide advice one way or the other that have changed from the previous years.
Okay. Did you advise the Attorney General's office on those grants before October of 2020?
On the specific grants that...
The federal money, that the $1 to $10 million is supposed to be coming to the state of Texas to help the AG's office.
Right.
Did you provide any advice about that before October of 2020?
Not. So just to clarify your question, these grants are typically on a 2-year cycle in most instances. So each time we would consider those a separate grant. So when you ask if I provided advice on these grants, historically, I would have advised on the legal nature of participating in these grant programs at different years.
Did you ever raise your concerns about the Attorney General's being indicted for securities fraud over the last 8 years to anyone before October of 2020?
I don't recall so.
I need to circle back with you and clean something up on the Public Information Act stuff that we talked about yesterday, okay? I want to make sure I have this right, because I think we may have made a mistake, you and I together, or I may have made the mistake and elicited testimony that was not correct. I want to make sure, okay? You remember the 3 requests we talked about yesterday, right?
Yes.
Okay.
The Securities Board, the big request, the FBI brief.
The FBI brief. So on the FBI brief, yesterday I believe I elicited testimony from you that the FBI blew their response deadline, but that wasn't right, was it?
I think is what I testified yesterday is I don't recall exactly what the circumstances were regarding the response deadline or any response that we had requested.
What actually happened is the FBI responded when that unredacted brief was requested, but their arguments were so nonsensical or non-responsive to the issue that your opinions division, which is under your oversight, made the decision to release the unredacted brief. True?
I don't recall what the brief said, the FBI's response to the request for the FBI brief itself. I don't recall what the FBI's position was or what the division issued. Just to put it in context, my youngest was born May 30th of 2020.
Okay.
So I was working out of the office, and at that time, if you recall, the DPS request, the big request, was issued June 2nd. So toward May 30th for the month of June, most of those conversations were directly with Ryan Bangert.
Okay, so is it true that you can't tell, ladies and gentlemen of the jury, why the unredacted brief was released?
The unredacted FBI brief was released because General Paxton directed us to release it.
And tell me about what that process was.
Well, in a meeting with General Paxton, at which Ryan Bangert was attending, we identified that the agency, the Office of the Attorney General, had received a request for public information for the FBI brief. General Paxton asked us to provide him a copy of the redacted brief and the unredacted brief.
Yes?
A few days later, we met again, and General Paxton had reviewed it, had marked up the copies, and indicated to both of us that he had seen nothing that should be withheld from Nate Paul.
Did you disagree with him?
Yes, just based on the content of the information.
Was there any claim of law enforcement privilege made by the FBI?
I'm not advised. Again, I don't recall what their brief said.
You don't recall any of the content of what the FBI said in their challenge?
Not in the challenge, no, sir. I recall the content of the FBI brief that was submitted as part of the DPS file.
Okay. I'm going to show you a few other documents, okay? We're going to go to stay on the same topic. This is Exhibit AG 185, Your Honor, if I might approach.
You may.
Have you had an opportunity to review Exhibit AG 185?
Yes, sir.
What is it?
It's a letter dated April 13th, 2020 from the Department of Public Safety to Joseph Larson regarding a public information request referenced as 20-0983.
And Mr. Arroyo, if you'd bring up Exhibit AG 185. Thank you so much.
Pardon me.
Counselor, are you offering this?
I am. I thought I did. I'm sorry. Exhibit AG 185, we move for admission, Mr. President.
Mr. Harden?
So, I have no objection, but I request that we don't put it up on the easel and pass until we get a ruling, please. Thank you so much.
Agreed.
I agree. Now, Mr. Arroyo, please.
And Mr. Counselor, since we did break for a half hour earlier, that was kind of our 10:30 break, so we'll go to 12, about 40 minutes, and then we'll have lunch from 12 to 1.
Understood, Judge. Thank you. This is a response from DPS to the big request, right?
It appears to be. I don't recall the exact number of the request, but it appears to be.
So Joe Larson is the vehicle that Nate Paul is using to make these requests, yes?
It was my understanding. That's right.
And then the lawsuit that Joe Larson filed, he filed that on behalf of Nate Paul, true?
Well, that lawsuit that you showed me yesterday, it identified Mr. Larson as the plaintiff. I don't know why he would have filed it or what reasons he had.
Ultimately, the unredacted FBI brief was released from a lawyer, at the Attorney General's office to a lawyer, Joe Larson, who is working for Nate Paul. True?
I believe so.
No one at the Attorney General's office tried to stop it from going out, did they?
Except for our conversations with General Paxton, I don't think anybody stopped it after he instructed us to release it.
But you didn't have any good legal reason to keep it, did you?
I'm not sure what you mean by legal reason to keep it.
You're a lawyer. Did you have a good legal reason to keep it?
Well, we had reasons to believe that the information contained in the brief itself involved law enforcement information under the Public Information Act, because, as you mentioned yesterday, the FBI redacted it.
But the FBI didn't assert law enforcement privilege over the brief, did it?
I don't recall what their position was in their briefing that they submitted, just because...
You don't know?
That's right.
Okay. Your Honor, I've got another exhibit. May I approach the witness?
Yes, you may.
Have you seen exhibit AG 253 before?
Yes, sir.
What is it?
This is a...
Are you offering this?
I was going to lay the predicate first, but I will certainly offer it.
Excuse me, Your Honor. Thank you. We have no objections. If I speed it up.
Exhibit 253, admitted to evidence. Continue.
Thank you. Mr. Arroyo, if you would, exhibit AG 253. Mr. Vassar, what is it?
This is a letter involving private schools in the middle of COVID-19. It's dated July 17th of 2020.
And Attorney General Ken Paxton issued this guidance, correct?
Yes, he signed it, and we issued it from the office.
And it is not a formal legal opinion, correct?
No, it's not a formal opinion decided under 402.
Okay. Did you have kids in a religious school at that time?
No, sir.
Okay. The purpose of this guidance was what?
To provide guidance on how religious private schools could operate in the face of local orders that may contradict the governor's executive orders at the time.
Pretty important stuff, isn't it?
Yes, sir.
And orders like this orders similar to this that were giving informal legal guidance about COVID matters were coming out of your office almost every day. True?
I'm not sure if it was daily, but we were providing advice on a regular basis.
All right. You recall the quote-unquote midnight opinion. I believe Mr. Hardin referred to it as the midnight opinion, the foreclosure guidance.
I recall it. Yes, sir.
May I approach the witness, Your Honor?
Yes, you may.
That wasn't even the only COVID guidance issued that day, was it?
I don't recall that specifically either.
Thank you.
Mr. President, we move for admission of Exhibit AG 7.
Mr. Hardin?
I'm trying to get my microphone on. I'm sorry. We have no objection, Your Honor.
Admit exhibit number 7 into evidence.
Have you seen... No, that's not AG 7. This is 260. Will you put AG 7, please, Mr. Arroyo? Thank you, Eric. Eric, would you zoom in on the letterhead here? This is the letterhead of the Office of the Attorney General of the State of Texas. True?
I wouldn't state that it's the only letterhead of the Office of the Attorney General, just based on my previous testimony.
Well, we'll see how common it is in a minute. This is the letterhead that went out on formal statements legal guidance, informal legal opinions, true?
Yes, it was used in those instances.
All right. This Exhibit AG7 was sent to a man named Brian Mukey, who's of the city of Hedwig Village. Do you know where the city of Hedwig Village is?
No, sir.
It's in the Houston area, but let's zoom out a little bit. Give me to the text, Eric, if you would. And capture Austin's signature too. I'm sorry, sir. What's this about?
This is the first time I've seen this letter that I can recall. It is issued under Section 418.193, which is the Disaster Act. It appears to be in response to a question that the mayor had asked about a local health authority's power to close schools.
And Austin Kinghorn works for you, true?
Yes, sir, at the time.
And you knew this was going out, right?
No, sir.
Why not?
Just based on the substance, this seems more like a pro forma response that doesn't need to be raised to the deputy level to make a decision. This seems to be consistent with advice that we had already issued, and it was essentially reiterating that advice and not taking a contrary statement.
Okay, so Austin, this was a minor enough issue that Austin could do this on his own, right?
No. So Austin worked in the general counsel division. That division chief is responsible for that division. I oversaw that division in addition to other divisions. So I did not have a daily oversight of the activities of that division.
He's in your downline, true?
Yes, sir.
What's the date on this?
August 1st of 2020.
That's a Saturday, isn't it?
Possibly. I don't recall what day that would have fallen on.
It's the same Saturday as the foreclosure guidance, true?
If that was a Saturday, then yes, it would have been the same day.
Well, you know the foreclosure guidance is dated August 1, right?
I don't recall if it's dated August 1. It might be August 2nd.
Isn't it true, sir, that there were so many needs in this big state related to guidance about COVID that your office was working on it constantly?
It was a perpetual theme.
Let's see how perpetual it is. May I approach the witness?
Yes, you may.
Thank you.
We move for admission of Exhibit AG 260.
Give Mr. Harden a moment.
I have no objection.
Admit Exhibit 260 into evidence.
Thank you. Mr. Arroyo, if you would. Same letterhead, yes?
Yes, sir. It's the same as the August 1st letter.
July 28, 2020, 3 days earlier, yes?
Yes, sir.
And who's Doug Sveen? Hope I'm saying that right.
This letter indicates he's the mayor of Stephenville, Texas.
He's asking about closure of schools, right?
That's right.
May I approach the witness, Your Honor?
Yes, you may.
I'm going to try to do this in bulk and maybe move this along a little bit. Your Honor, we move for admission of AG Exhibits 259 and 6.
We have no objection, and we have no objection to 289, and we have no objection to Exhibit 6.
Admit Exhibit 6 and 259 into evidence.
Mr. Arroyo, Exhibit 259, please. Who's Craig Morgan?
This letter refers to him as the mayor of Round Rock.
That's on a Thursday before August 1st, right?
Sure.
What's it about?
This appears to be the City of Round Rock's decision to move its local election from November 3rd of 2020 to May of 2021.
Why do they want to move it?
I think the reason that they had stated was because of COVID.
Who issued the opinion?
It was signed by General Paxton.
Does it have a KP number?
No, sir.
Not a formal legal opinion, true?
No, it was not issued as a formal opinion under 402.
Mr. Arroyo, Exhibit 6, please. AG Exhibit 6. August 3, Monday. Who's the Honorable Vince Ryan?
The Harris County Attorney.
This is a formal legal opinion, yes?
Yes, this is a formal opinion issued under Chapter 402.
Tell the ladies and gentlemen of the jury how they can tell by looking at this document that it's a formal legal opinion.
After the mailing address, there is an opinion number that's referenced. And then in the subject line, there is a request number that's also referenced.
And every formal legal opinion from the Office of the Attorney General under Chapter 402 of the Government Code has both. True?
Yes.
And what's this letter about?
It's regarding the county authority to require masks in courtrooms, courthouses, and county buildings.
Okay, so correct me if I'm wrong. July 28th, July 30th, August 1, August 1, August 3. There are opinions coming out almost every day about COVID stuff during this period of time, true?
Well, again, to clarify, a lot of the questions that we would get would follow the governor's executive orders, which were coming out in different points. So if an executive order was issued, the frequency of our requests for advice might increase. I can't testify that we were releasing information daily. I don't know if that's actually true, but I can say it was happening regularly just with the pattern of executive orders or mayoral or county orders.
Isn't it true that the office was constantly adapting to the executive orders of the governor's office, the executive orders of President Donald J. Trump?
Absolutely.
And that actually increased the amount of informal legal advice and the need for it on a literally day-to-day basis.
Well, again, it was very frequent, just given the number of agencies that were involved on a state level as well as the federal level.
Mr. President, a moment, if I may.
Yes?
Oh, I'm sorry. I apologize. I thought you were passing the witness. I
No,
apologize.
you ought to keep coming. Pass the witness.
I apologize.
Mr. Hardin, he passed the witness. Just you standing up made it all happen. We'll go to the top of the hour, Mr. Hardin.
Good morning, Mr. Vassar.
Good morning.
I'm going to try to, as best I can, to do this pretty quickly. Thank you so much. We've got several areas here. We can just start where we finished up. I thought I would never have to talk about the different numbers of the different portions of the government code that suggested what y'all should and should not do. But I think council's appropriately covered back on the issue, and so I feel compelled to a little bit just try to clear this up just a tad. The two sections of the government code that you folks would have been working over primarily, that you've been testifying to council about on cross are what numbers in the code?
Chapter 402 of the Government Code and Chapter 418.
All right. Now, let me see if I can do this briefly with you. How do you determine which of those codes apply to a request for an opinion, or the sections of the code, excuse me?
So Chapter 402 enables the Attorney General to provide general legal guidance in response to a request from an eligible requester. Chapter 418 is expressly limited to providing advice relating to a disaster declaration, again, to eligible requesters who are different from Chapter 402.
All right. For instance, does which one of those sections apply depend on the identity of the requester that makes the request?
Yes, sir.
And does 418, something that I believe, did you testify earlier, that 418 was amended, the National Disaster Act, before COVID, but when COVID came, was frequently used as the basis as to answer a query from a public official?
That's correct. I believe it was amended in 2019. Obviously, COVID hit in 2020, so that provided an avenue for local officials to request legal advice from our office.
Now, if when General Paxton requested y'all to do this hurry-up opinion, if he had come up with a requester that was a mayor, what section of the code would have applied to the opinion that you folks wrote?
Just based on the fact that it was a COVID-related question and that the mayor is an authorized requester, it would have fallen under Chapter 418.
Now, once it was decided that the requester would be a state senator, which section of the code did that mean would cover what you did?
A state senator who is a chair of a legislative committee.
Thank you. Excuse me for interrupting you. That's the caveat. It's not just a state senator, but it has to be a chairman, does it not?
That's right.
All right, resume the answer, please.
A state senator who is a chair of a legislative committee is an authorized requester under Chapter 402.
All right. And is the significance that 402 was applied here is that Section 402 does not distinguish between an informal and a formal opinion, correct?
That's correct. It does not.
Now, if we move forward, that it had gone through if it hadn't been a hurry up and went through your normal process as you testified that would take ordinarily about 6 months, is there a difference in the way the 6-month opinions which are vetted and published in 6 months as opposed to overnight is with what we've called this opinion? What would be the difference in the way those two opinions, heavily researched, vetted opinion, overnight opinion, how are those reported to the public and dealt with as far as publishing to the world?
So under Chapter 402, if it's an eligible request, our agency logs it as a request, publishes that request in the Texas Register, which enables third parties who are just interested in submitting their own briefing and arguments to our office. After a drafting period in the division, it's reviewed internally, and including other divisions who might have subject matter expertise on the issue. After all of the division feedback is received, it's circulated to the deputy level and the executive for review and approval. After it is issued, it's then, again, recorded on our website and then published in the Texas Register for public dissemination. And I believe it's also uploaded to Westlaw.
So is one much more widely distributed and easily published to the world than the other?
Yes, sir.
Finally, you were asked about things I think you said you did not know about in terms of the next day or a hearing that you were not involved about, correct?
The hearing.
Very good question. Let me rephrase it. That's a very good question. Do you recall being questioned about what you knew about how the overnight opinion was used on behalf of Mr. Paul?
Yes, I recall that.
You recall you said you were not aware at the time. Do you recall that?
That's right.
All right. Have you become aware, and did you see a document during your examination that showed a lawyer on behalf of Mr. Paul immediately within 36 hours or 24 hours was using that in a court to try to get what he wanted?
Yes, sir. I believe in one of the exhibits that I reviewed, there was a statement indicating that the foreclosure letter that we had issued was used to stop a foreclosure sale related to Nate Paul.
Do you have any idea how one would have known as early as Monday to be prepared to use that in a hearing on Tuesday when you only completed it at 1 o'clock Sunday morning and sent it to the Attorney General sometime Sunday?
Objection, Mr. President, leading and calls for speculation.
Sustained.
Now, let's go to a couple other areas. You recall you were questioned considerably about first of all, the interview that he asked you about a little bit toward the end. And that is that you were not under oath at that hearing.
I recall that. Yes, sir.
And I said hearing, I don't mean hearing. It was really an interview by investigators, many are here today, that were retained by the House Management Committee, or the House Committee rather, to do an investigation. You recall that series of events?
Yes, sir.
And I believe you were shown some of the testimony, again, not testimony, some of the interview statement that you gave.
Yes, sir.
Now, did you readily agree to have it videotaped?
Yes, I believe when I sat down, there was a recording that was going to be used for my interview.
Do you remember sort of fumbling around that nobody had a recorder, they had to go get one?
Yes, sir.
All right. But at any rate, ultimately, when that happened, did you have any objection to it being videotaped and audioed?
No, sir.
Now, did anybody at all suggest placing you under oath?
No, sir.
Do you know enough about law enforcement as to whether or not ordinarily, if somebody's trying to gather information as part of a law enforcement information or investigation, where they would swear to people when they're just trying to get people to tell them what happened?
Your Honor, I have to object as being argumentative and sidebar.
I withdraw.
Sustained.
Thank you, Judge. Thank you. I'll withdraw the question, but I waited too late. All right. So, if I may, at any rate, you gave that interview, correct? And
right.
I told him. And that interview was totally available as evidenced by questions you got to the other side, correct?
I believe so, yes. I'm not, yes.
And in that one item that it came up with, there's no suggestion that you've testified any differently today than you did to these investigators, correct?
Objection, leading and argumentative.
Sustained.
Are you under oath today?
Yes, sir, I am.
Did you testify today the same you did to these House investigators?
Yes, sir.
Can we take that as evidence of the fact nobody's suggesting otherwise?
Object to the argument, Mr. President.
Now,
Sustained.
if I can, you were asked about evidence. Do you recall this? Evidence that you took to the FBI.
Yes, sir, I recall.
And 7 of you went to the FBI, did you not, on the 30th of September 2020?
Yes, sir.
And you took no documents, did you?
That's right. No documents.
Who did you take?
We took ourselves.
And you took yourselves to do what?
To provide an explanation of the sequences of events that we had determined
Well, when
revealed information tending to show that General Paxton had abused his office and the powers and responsibility and trust that millions of Texans bestowed upon him to benefit one individual.
And when you went, if you had taken things with you, you would have had to take things that were the property of the Attorney General's office, wouldn't you?
Objection, Your Honor. Calls for speculation and a legal conclusion.
Excuse me.
Sustained.
Would you have had any documents other than things that were circulated and created right there in the AG's office?
Objection, Your Honor. Speculation and argument.
I'm really asking him if anything they took would have had to, as evidence, would have had to be property of the Attorney General's office.
Overruled, you may
Thank you.
answer the question.
You can answer that.
All of the information would have been information that we had obtained just by virtue of our employment at the agency.
Now, when you answered the question, you recall answering the question is you had no evidence that you took to the FBI in that meeting, correct? Do you recall that answer?
Yes, sir, I do.
Well, tell me what you mean by that answer when you say you took no evidence.
Well, the way that I interpreted opposing counsel's question was documents, documentary evidence of what we took to the meeting with the FBI for law enforcement.
After this position, you might want to say, thank God, but you're not a trial lawyer, are you?
No, sir.
Do you have any idea how evidence is defined in terms of law enforcement or people wanting to find out what happened in a situation?
Objection, Your Honor. Calls for speculation. Legal
No,
conclusion.
I'm asking his
argument.
mind. Does he have any idea? That's all I'm asking.
Sustained, rephrase.
All right. In this particular situation, did you take your body?
Yes, sir.
Did you take your voice?
Yes, sir.
Did you take your brain?
Yes, sir.
Did you take your experience?
Yes, sir.
Did you take your knowledge of the last 9 months?
Yes, sir.
Did you take what things you personally knew of in addition to going with people who may have known other things?
Absolutely.
Did you tell the FBI that?
Every bit of it.
Do you realize in the legal world that is evidence?
Objection leading.
No, that is simply a fact statement. That is not leading, in my
Sustained.
respect. And the court disagrees, which is why we're here. Let me ask you this. If you told all of those people what you knew in your mind and what you were concerned about, what is your opinion now after the primer we just did as to whether you gave the FBI evidence?
Object leading. Argumentative. This is closing statement, not a question for the witness.
I've asked him what his opinion, excuse me, Your Honor, I asked him what his opinion is. I didn't
Overruled.
ask him. Thank you.
My opinion was that our experiences were evidence, but we did not conduct our own investigation to provide documentary evidence of what we had come to learn.
Well, what did you provide him?
Just our experiences.
What do you mean?
The situations in which General Paxton asked us to act involving Nate Paul, the cumulative knowledge of the conversations that we had as a group between September 29th and the morning of September 30th, once the grand jury subpoenas for Brandon Kamek started coming to the office.
Whose job then, in your opinion, was it then to conduct the investigation?
Federal law enforcement.
Did you ever view yourself as an investigator in this matter?
No, sir.
What did you think you were when you went to the FBI?
We were witnesses.
Pardon me?
I believe that I was a witness to criminal activity that had occurred by General Paxton.
Right. Do you know of any other occasion in which the Attorney General involved himself in the drafting of an opinion such as what you did in August on the issue of foreclosures?
I can't think of any. No, sir.
Finally, maybe from your age you don't know this. Are you familiar with the movie Cool Hand Luke?
I've heard of it. I'm not familiar with it.
You ever see the scene in a very, very bad moment in the movie, for at least a bad moment for Paul Newman, in which the bad guy stands over there as he's digging and says, what we have here is a failure. Let me just finish. A failure to communicate. That's just the question.
Overruled, and you were allowed to finish.
Thank you. Have you?
I've not.
All right. let's talk about these supposed altered documents. All right? You tried several times, did you not, on your cross to explain there were different types of letterhead papers in the AG's office. Do you recall telling him that?
Yes, sir.
You recall he went right by. He didn't want to deal with that, did he?
That's right.
All right, well, let's deal with it real quickly. For instance, in the Attorney General's office, did y'all periodically use one type of paper that did not have General Paxton's on it and another type of paper that did?
Yes, sir.
Do you have any idea how the circumstances were that dictated which you would use?
No, sir.
All right. On the occasion when the letter that we've been talking about, that they have been complaining was altered and the Attorney General's name was taken off, was that letter complaining about the Attorney General?
Yes, sir, it was.
Well, if you're writing a letter complaining about the Attorney General, what is your opinion as whether you would want to make sure his name wasn't on there for a letter complaining about him?
Objection leading.
Sustained.
Let me ask you this. I'm going to show you a letter that is already in evidence, Exhibit 127. May I have it on the screen, please? Is that an altered letter?
Counselor, excuse me, we don't show that being already entered.
You do not show it's in?
Oh, it's in.
Thank you.
Our apology.
No, not at all. I misled you by making you think which one it was. We were both inadvertent. But I think it is interesting to point. Would you look down to the bottom? Would you cyclize where the exhibit and whose exhibit this is? And let's sort of, if we can, highlight, Stacy, both from whom the production was that produced it to us. OAG stands for what?
The Office of the Attorney General.
And are you familiar enough, reluctantly, about this process to know what AG exhibit means?
That appears to be a reference to an exhibit that the Attorney General's defense team has offered as evidence.
Yes. Would you expect them to offer an altered document?
No, sir, I would not.
All right. Well, in this offer, is the Attorney General's name on it?
His name is not on the seal at the top of the document.
Is this seal identical to the seal that y'all used for the letter you wrote before you went to the FBI?
Yes, sir, it is.
Or after you came back? I can't remember what. I don't want to misstate when it was.
It was drafted and reported or sent to HR after we returned from meeting with law enforcement.
All right. So it would have been on the 20th, when you came back on the 30th?
30th,
when
yes,
you
sir.
came back on the 30th. Thank you. All right, now, let's go to the next to last page, I believe, of this exhibit. Do you see who it's signed by?
It's signed by Jeff Petier.
Now, Stacy, just to test your agility, will you go back to the front page again and isolate the date this was? What's the date?
That date is October 1st of 2020.
All right. Now I'm going to show you some that have not been introduced, and I will first tender. Do we have copies of our Exhibit 633. I'm going to move to introduce. I was waiting for you to review it.
Oh, thank you. No objection, Judge.
Admit Exhibit 633 into evidence.
Can you put it up on the screen, please? Thank you. Would you give us, publish for the jury, the date of this letter?
This letter is dated January 28th of 2020.
Yes. And would this have been in connection with any particular event? Have you ever seen this letter, or do you know anything about this?
I don't recall exactly if I was involved in reviewing it. Again, I was appointed Deputy AG for Legal Counsel April 1st of 2020. It's possible I reviewed it, excuse me, in the General Counsel Division, but I have not seen it since.
And the letter is signed by whom?
It's signed by General Paxton.
Now, we can assume, can we not, that General Paxton didn't alter this letter?
I wouldn't presume so.
And is it also similar to the letter y'all sent on paper that has just the seal?
That's the same seal, yes, sir.
So let's once again make sure there's no misunderstanding. Or do you understand for the last 4 days you folks have been accused of altering a document?
This is a violation of the rule, Mr. President.
Let me put it another way. I'll put it another way, Your Honor.
Was there an objection?
Objection violates the rule.
Sustained.
If anybody was to suggest that you guys had, when you wrote your letter, that you had somehow altered it and taken the Attorney General's name off and therefore altered a government document, would that be true or not true?
That's not true.
Would it actually be a lie?
As these documents indicate, there are different seals for different purposes. And in this situation, we used the seal without General Paxton's name on it. That's the seal that was...
You are indeed, are you not, Mr. Vassar, a kind and gentle person. So much so that even after enduring yelling and constant interruption, you still don't like to use the word lie, do you?
Objection to leading an argument.
I have no further questions.
Objection sustained. We will hold your... Do you intend to recross?
I do, Mr. President, but I could probably resolve in about 3 minutes.
I'll give you 3 minutes.
Thank you, Judge.
In 5 at the most. There you go.
I will try to yield some back, Mr. President. So it's okay to give your personal lawyer documents from inside the Office of the Attorney General, but not the FBI, right?
I provided documents under a grand jury subpoena that I received to my lawyer, so I don't know what the implication is.
You had internal OAG documents, to wit, a series of grand jury subpoenas that were served by Brandon Kamak that you sent to your personal lawyer, but you didn't bring any documents to the FBI, right?
That's absolutely true.
And you went to the FBI, David Maxwell went to Travis County, they investigated, and they still have done nothing, true?
I don't know what they found. I know it's an ongoing investigation.
Mr. Hardin talked to you about the letter that Nate Paul wrote to the court about the OAG foreclosure guidance. Do you recall that testimony, those questions?
Yes.
All right, Your Honor, Mr. President, I have one copy of AG Exhibit 286, If I may, I will tender it to Mr. Hardin for his review, and then to Your Honor, and then to Mr. Vassar.
You may.
I have no objection.
What is the number on that?
Mr. President, is AG Exhibit 286, and we move for its admission.
The Exhibit 286 will be admitted into evidence.
Mr. Arroyo, if you could assist us, please, very briefly. Mr. Vassar, who's Stephen Benish?
I have no idea.
You should know him. He's your state bar president-elect. This is a letter from Stephen Benish, who was opposing counsel to Nate Paul in the WC 4th and Colorado matter, and he wrote a letter. Mr. Arroyo, please blow up the text of his letter. Mr. Benish says in response to Nate Paul's letter, like lawyers often do, I disagree. And he wrote to the judge and he said, the foreclosure sale isn't being stopped by this OAG informal guidance, right?
I've never seen this before, but I see where he says the AG's, quote, informal guidance does not emphasize, state that foreclosure sales may not proceed unless specifically authorized by the mayor in the city of the foreclosure.
And what happens in courts is one side makes an argument and the other side makes an argument and the judge decides, right?
Yes, sir.
Only in this case, Nate Paul put his entity in bankruptcy to stop the foreclosure, right?
I'm not sure.
That will be all, Mr. President.
Thank you, Counselor. We will break until 1 p.m. Could I have one of the House managers come up and one from the defense come up just to clarify if the witness has been excused? I want to be sure there was not a redirect. A reread. Okay.
For rebuttal or whatever, you're not redirecting him again.
All rise. The Court of Impeachment of the Texas Senate is now in session.
I was asked to do this this morning, so I'll update you now as we go into the afternoon session. Time remaining, the respondents have 16 hours, 2 minutes and 19 seconds. The House has 15 hours, 33 minutes and 2 seconds. So by the end of today, around 6 o'clock, we will likely be past the halfway mark, or close to it, of time. And I know to both parties, when we met last week and talked earlier this week, I asked for both parties to conduct themselves in an appropriate manner for this historic event. And I want to thank both parties because I believe everyone has conducted themselves at a very high level of professionalism, and hopefully we finish the second half of the trial doing the same. And I have no reason not to believe that will happen. Mr. DeGuerin?
Yes, Mr. President. The House calls former Texas Ranger and former Director of the Law Enforcement Division of the Attorney General's Office, David Maxwell.
Bailiff, will you bring in Ranger Maxwell? Counsel, there's some documents up here left over. I'm not sure whose they are. Okay. Thank you.
Please don't ask me to control the witness.
Mr. Maxwell, did you swear in the other day? You did not? I did not. Okay. Repeat after me. I do solemnly swear and affirm. I do solemnly swear and affirm. And affirm. As a witness in the impeachment proceeding. Shall be admitted. I'm sorry. I read the wrong line. Let me start from the beginning. I do solemnly swear and affirm, you've read that the evidence I give upon this hearing, the Senate of Texas impeachment, charges against Warren Kenneth Paxton Jr., shall be the truth, the whole truth, and nothing but the truth. So help me God. Please be seated. You may begin.
If you'll move that microphone pretty close, we have a little problem with acoustics in here. Please tell the senators your name. Yep. Got it.
There we go. My name is David Maxwell.
Mr. Maxwell, your last position with the Attorney General was as Director of Law Enforcement. Is that correct?
That is correct.
I want to ask you some questions about your law enforcement career. Can you tell us where you started and when?
I started in 1972 with the Texas Department of Public Safety. I went through the patrol school, graduated April 6 of 1973. Spent 8 years working highway patrol in Harris County. I promoted to narcotics in 1981. and worked narcotics in Harris County for 5 years. Then promoted to Texas Rangers in 1986.
Let me stop you there just for a second. Those of us who were raised in Texas know a lot about, or think we know a lot about the Texas Rangers. What does it take to become a Texas Ranger?
First of all, you have to have 8 years of experience with DPS to be able to apply for the position. When I applied in 1986, it was a little different than it is now, but we had to take a written examination to qualify to go before the oral interview board, and then they would score the oral interview board and combine the two, and then they took the top 5 people and put them on a list for 1 year. If you didn't get promoted in that 1 year, you went back to the first step and started over.
How long did you serve the state of Texas as a Texas Ranger?
25 years as Texas Ranger.
And when you left the Ranger service, where did you go?
I went to the Texas Attorney General's office.
What was your first position there?
My first position was Deputy Director of Law Enforcement.
And did you promote to the Director of Law Enforcement?
I did.
I want to pull up for, please, the organizational chart. It'll be in front of you. I'll ask you a couple of questions about that.
Okay.
Your name and, your name has been highlighted, and it appears to be on a level with other deputies. So what was your rank in the Attorney General's office as it relates to the Deputy Attorney Generals?
I was the Executive Deputy over Law Enforcement Division.
Is that an equal rank with the deputies that were deputies over the other divisions of the Attorney General's office?
Yes, and I was the most senior deputy.
Most senior, how?
I had more time as an executive deputy than the others who were working with me at that time.
How many employees, law enforcement officers and support staff, as well as attorneys, did you supervise?
I had about 350 employees, 205 were commissioned officers, and 19 of them were attorneys.
Were those employees spread out across the state, or were they only in Austin?
We had a majority of them in Austin, but we also had offices around the state.
What is and was, when you were director, the authority of the Law Enforcement Division of the Attorney General's office?
The authority was that of other peace officers in the state. We had jurisdiction over any type of crime that would be committed against the state of Texas.
Did you have a criteria for opening a case as an investigator to be investigated by the Attorney General's Office Criminal Division?
I did.
What was that criteria?
This is the criteria that I set up for investigating public officials. So I had certain requirements. First of all, I reviewed all the requests that came in for investigations on public officials. And we had a lot of requests, and I didn't approve but just a few every year. We already worked as many cases on public corruption as the Texas Rangers who have statutory authority. So we worked.
Excuse me, Your Honor. Excuse me. Non-responsive. The question was, what was your criteria?
What was your criteria for opening an investigation?
The criteria was, at first, I had to have a sworn signed statement from the person who was making the allegation. The second thing was that I had to have a letter from the district attorney who had jurisdiction over the possible cases, saying that they would prosecute those cases if we were able to prove that a case was viable.
Why did you have a criteria such as that, particularly when it comes to investigating public officials?
I set up the criteria in order not to be pulled into situations that are strictly political in nature. I did not want us to be in the position of investigating public officials when there was really no crime being committed.
And did this criteria particularly apply to investigations of public integrity?
Yes.
Do you know who was the district attorney in Travis County in the year 2020?
Margaret Moore.
Did you have a good relationship with Margaret Moore?
I did.
I want to get right to the matters here. Were you asked in some way to meet with a person named Nate Paul?
Yes.
Who asked you to do that?
Jeff Mateer.
Where did Jeff Mateer tell you who had told him to have you meet with Nate Paul?
Objection, hearsay.
That's not hearsay under 803 and 801E2D, Your Honor, with respect.
Mr. Mateer is not alleged to have been a co-conspirator. Objection, hearsay.
It's not.
Hold on one moment. Hold on. And we've been doing a really good job of not using a lot of numbers. I have my whole chart here. It's better for just to say what the answer objection is, but this is why I have legal counsel here.
Yes, it's 801
Yes.
E2D.
Overruled.
All right, you may state your answer. And the question is, did Mr. Mateer tell you who ordered him to order you to meet with Nate Paul?
Yes.
What did he say?
He said General Paxton ordered me to meet with this individual, that he had a story to tell.
At about the same time, did you hear from an employee of the Travis County District Attorney's Office about Nate Paul?
I did.
I'm going to ask you about that in a minute, but when you first were asked to meet with Nate Paul, did you do some research of your own?
I did.
And what did you find?
I found on the internet that...
Excuse me, with all due respect to Ranger Maxwell, if he's going to recite information that he obtained doing his research, that would be hearsay.
It goes to his state of mind in conducting the investigation, Your Honor, and thus is not hearsay.
It is hearsay.
Well,
Overruled. Continue.
okay. So what did you find when you made your initial investigation of Nate Paul?
I found that Nate Paul was being investigated by the FBI, that they had run search warrants in August of 2019 on his business and his home and a storage facility. I found articles in business journals that talked about lawsuits.
Excuse me. Objection, hearsay. Articles in business journals, that's definitionally hearsay.
Again, it goes to his state of mind, and it's the same. He's answering the same question that the court allowed.
With all due respect, he can testify to what's in his mind under this exception. He can't testify as what the article said.
Sustained.
Nonetheless, did you form an opinion of your state of mind?
I did.
And what was that?
My opinion that Nate Paul was a criminal and that we should not be associated with Nate Paul.
At about the same time, did you receive communication from the Travis County District Attorney's Office?
I did.
Your Honor, we have an agreement on House Exhibit 615, which we moved to introduce.
Could I see it, Dick, real quick? I'm sure you're right. Yes. No objection.
It's been admitted. Both sides have agreed.
If we could bring up closer, yeah. I'm being told to tell you to get closer to the mic.
Mr. Maxwell, they just asked you to get closer to the mic when you speak.
Closer to the mic? Yeah. Is that better?
You can pull that towards you a little bit if you'd like.
Okay.
You can pull the whole outfit closer to you.
Okay.
This is the first page. This is the email, and it references a letter. Let's go to the second page, please.
Yes, it was from Don Clemmer.
All right, here's a letter from Don Clemmer. It's dated June 10th, 2020. It's to you. And let's just read it into the record. I am forwarding to you the attached complaint, which was recently received by my office regarding allegations of misconduct by employees of the State Securities Board, the Federal Bureau of Investigations, the Department of Public Safety, the United States Attorney's Office for the Western District of Texas, and a federal magistrate. My office would typically forward such a complaint to the Public Integrity Unit of the Texas Rangers for review. However, since an employee of the Department of Public Safety is one of the subjects of the complaint, referral to the Rangers would appear inappropriate. I am therefore requesting that your agency conduct the review. My first question, is the word review significant?
Yes.
What is its significance?
In the protocols that we had set forth, we first review the request before we ever make a determination on whether we'd actually open up an investigation.
Now, you're familiar with a district attorney's office excusing or recusing itself from an investigation, aren't you?
Yes.
Is that what this was?
Yes, they were forwarding it to us. They didn't feel like that it was up to them to do this investigation.
Now, we saw the email that Mr. Clemmer sent about the same time, and it mentions that you should call him if you'd like. Did you call him?
Yes, I did.
And did you talk to him?
Yes, I did.
What did he tell you?
Excuse me, objection.
It comes in, I know he's going to object to hearsay. Under Rule 803.3, it's an expression by Mr. Clemmer of his then existing motive, intent, and plan.
Not only do I have to object, I want to object. Hearsay.
Yeah, sustained.
Maybe I didn't clearly state my citation of the code or of the evidence rules, Your Honor, 803.3.
I've ruled. Continue.
All right. Whatever, and don't go into the words that Mr. Clemmer said, was it consistent with what you had already found, or the suspicions that you already had?
Yes.
And what were your suspicions?
That the referral was being requested by General Paxton.
And what about the validity of the referral and the complaint?
Excuse me, objection, conjecture, and speculation.
No, this would be his evaluation, which was his job to do.
He hasn't done anything yet. Objection, conjecture, and speculation. You're asking him to testify as to the validity of a complaint which he hasn't investigated yet. That would be conjecture and speculation.
Let me lay a letter.
Overruled.
Okay, go ahead.
I can answer the question.
Yes.
My evaluation of the allegations made by Nate Paul is that they were absolutely ludicrous, without merit, no probable cause, not even reasonable belief that a crime had been committed.
Now let me step aside for just a moment and say, or ask you, what were the nature of the allegations that Mr. Nate Paul was making?
The nature of the allegations that he was making were against the FBI, an investigator with the Texas State Security Board, 2 U.S. attorneys, the senior federal magistrate, Mark Lane, and others who were involved in the chain of the signing and execution of the search warrants on his business, his place of storage, and also his home.
Now, one of your areas to investigate, one of your duties was to investigate public integrity, correct?
Yes.
if there had been credible allegations against the State Securities Board, the DPS, the FBI, federal magistrate, U.S. attorney, would you have any hesitation of going forward?
Objection, excuse me, objection, bolstering, and self-serving.
Overruled. Continue.
You may answer.
No, I would not.
Did you have any hesitation even to meet with Nate Paul?
I did not want to meet with Nate Paul, and I expressed my concerns to Jeff Mateer about that.
And what was the reply?
He said that he was getting a lot of pressure from General Paxton for me to do this.
All right. Let's go to July the 21st of 2020. Did you have a meeting with Nate Paul and his lawyer?
I did.
What was the reason you had that meeting?
I told Jeff Mateer that I would consent to let him tell his story, and that if he made any statements against his interest, I would report it to the FBI.
So on July the 21st, did you have the meeting?
I did.
Where?
It was on the first floor of the Clements building. It was in the office of our security office, where we have a conference room that has the capability of recording video and sound.
Who wanted that to be done? That is, record by video and sound the meeting, but with Nate Paul and his lawyer and yourself?
Me.
Are you familiar with a report that was later put out by the Attorney General's office claiming that General Paxton wanted that meeting recorded?
That is false.
So, have you reviewed the transcript of that meeting?
I have.
Are you aware that the lawyers for General Paxton have been supplied with both the audio and video and transcript of that meeting? What took place?
Okay. Yes, I'm aware of that.
Okay. What took place at that meeting?
Say it again.
What took place at that meeting?
Nate Paul laid out his conspiracy theory about what happened the day of the search warrants were executed. He had complaints about the procedural part that the FBI took when they were securing the scene and conducting the searches. And then he laid out his conspiracy theory that they had originally come to search for not records, but for drugs and guns. And that in the middle of the search, when they didn't find any drugs and guns, they then altered the search warrant to be the search warrant that was executed, where it was for records. And he further stated that the people involved in that was the FBI agent, the agent from the Texas Securities Board, Alan Bowie, who was AUSA, and Mark Lane, the senior magistrate.
So according to his complaint, a United States federal magistrate was involved in this conspiracy?
That's correct.
As a law enforcement officer of many years, what did you think of that?
It was ludicrous.
Did you ask for any documentation?
Yes, I did.
Are you familiar with the crime of obstruction of justice?
I am.
Are you familiar with the crime of interference of a law enforcement investigation?
Of a federal investigation, yes, I am.
What concerns did you have if you had started an investigation based on these claims by Mr. Paul?
My concerns that we would be interfering with a federal investigation. We could be charged with obstruction of justice, and based on a complaint that has absolutely no merit.
And at this time, even at this meeting, had your criteria for opening an investigation been satisfied?
No,
How so?
it doesn't meet any of my requirements.
After that meeting with Mr. Paul, and his lawyer, by the way, was Michael Wynn?
Michael Wynn was there.
Okay. After that meeting with Mr. Paul, did you have a meeting with the Attorney General, General Paxton?
I did not, after that meeting, immediately, no.
No, I don't mean that same day, but did you personally talk to Ken Paxton, the Attorney General, about what had happened in that meeting?
No, I did not.
What did you tell him about the meeting?
I'm sorry. I thought he said he did not meet with Mr. Paxton. And you just asked him what he told Paxton. One of us is confused.
Can we clarify that?
Yeah, could you clarify that? Did you tell him what you thought about that meeting?
I told him before the meeting ever occurred what I thought about us being involved with Nate Paul. That happened before the first meeting.
And what did you tell him?
I told him that he was a criminal.
Sorry. Excuse me, Ranger. Objection asked and answered. He just got through telling us what he told Paxton.
I don't believe it was asked. I don't believe he answered fully what I'm driving at. What did he tell General Paxton?
I'll sustain the objection, and you can try one more time again.
Maybe I'm not clear on it. Did you at some time tell General Paxton what you thought about this idea of Mr. Paul, that there was a vast conspiracy against him?
Yes.
What did you tell him?
I told him that Nate Paul was a criminal. He was running a Ponzi scheme that would rival Billy Saul Estes, and that if he didn't get away from this individual and stop doing what he was doing, he was going to get himself indicted.
Nonetheless, was there a second meeting between you and Nate Paul and Nate Paul's lawyer and Mark Penley?
There was.
Why was there a second meeting if you felt like you did after that first meeting?
Because he had talked to he had talked to Mark Penley and told him he wanted him to conduct another meeting with Nate Paul.
When you say he, are you referring to General Paxton?
General Paxton, that's correct.
So General Paxton had told Mr. Penley to get involved in this?
That is correct.
Excuse me. Objection. I'm sorry, Dick. Objection asked and answered. Ranger Maxwell will give his testimony, and Dick will ask him to repeat the same thing. Ask and answer.
I'm going to overrule that. Continue.
Yeah, I wanted to clarify and make sure that we understand. Mark Penley told you that General Paxton had ordered him to now get involved?
This is the third time. Objection asked and answered. He literally just got through testifying to that.
I believe that you allowed me to ask that.
Sustain.
All right. So, did you have a second meeting?
We did.
And was Mr. Penley involved in this one?
He was.
And what was Mr. Penley's role in the Attorney General's office? If we could have that organizational chart again.
Mr. Penley was the executive deputy over criminal prosecution.
So in this chart, he's just next to you, and it's now been highlighted for them for the jurors.
That's correct.
Was he your superior, or was he an equal of yours?
He was an equal.
And what was Mr. Penley's background, briefly?
He came to us from the U.S. Attorney's Office out of Dallas, where he'd been an assistant U.S. attorney.
So at this second meeting, where did it happen?
In the same place as before, in the Clements Building, ground floor, the security office, conference room.
Was it audio, video recorded?
It was.
And is there a transcript of that?
There is.
Have you reviewed that?
I have.
Are you aware that that has been provided to Attorney General Paxton's lawyers?
Yes.
All right. Who wanted that meeting recorded?
I did.
If there's any suggestion that General Paxton wanted that recorded, is that true or false?
Objection asked and answered.
That was the first one. That was the first one that we referred to.
Overruled.
Go ahead.
It's false.
Was there anything new brought up in that meeting as far as you were concerned? You were in both meetings.
He and his lawyer again reiterated the complaints and their conspiracy theory as they had done in the first meeting. I advised them.
Objection. Excuse me.
What did you advise?
Excuse me, Dick. The objection is non-responsive. The question was there anything new? Now Ranger Maxwell is going into what he told them. That's a different answer.
Sustained.
It's correct, and I was trying to meet his objection by going to the next question. So go ahead. The next question is, what happened?
What happened? So during the meeting, they continued to lay out their objections about what happened in the search warrants and the conspiracy theory about how all these different individuals came together and falsified a search warrant during the middle of the search. And I told them that if they believe that to be true, then why aren't they in the office of the Inspector General's office for the federal government, which has the authority to look into any of these complaints, and the FBI, the U.S. Attorney's Office, the federal magistrate, has to cooperate with them. And I asked them, why aren't you in that office?
Did you get a satisfactory answer to that?
They danced around the answer, but they said they felt like they were in the right place with us.
Did you receive any kind of documents to corroborate or to support that the search warrant had been changed mid-search?
They gave us some documents. They were supposed to give us all the documents, but when we reviewed the documents they gave us, it was not very much. And it certainly wasn't enough for us to really make a determination.
Even still, did you submit those documents to some experts within your office?
I did.
And what's the expertise of the people that you submitted these documents to?
This is my forensics section, who does all the forensics on computers and cell phones for criminal cases. And we do that work not only for ourselves, but for the Texas Rangers and others.
All right. By this time, which is, that meeting was August the 5th, by this time, had you become aware yet that General Paxton had ordered Josh Godbee and Mr. McCarty to push a charity to settle in a lawsuit?
No.
Objection.
And by that time...
Excuse me, Dick. Objection, leading, and assuming facts not in evidence to this witness.
I'm just asking if he was aware.
Sustained.
Were you aware that Ken Paxton had asked Ryan Bangert to change the state policy
No.
Were you aware that General Paxton had asked Ryan Vassar to release details of that very ongoing investigation?
Objection. That's a misstatement of the record, and it's assuming facts, not an evidence, through this witness.
Overruled.
You may answer.
No.
Did you later become aware of those things?
I did.
We'll get to that. Let's talk just for a moment about the records of a search. What is the general practice at least in federal courts, for the sealing, that is, making private the affidavit, the application for a search warrant?
They are sealed to protect people who are involved, may have given information about the crime that's being committed, and also for the purposes of protecting the investigation so it can be ongoing and find the truth.
Are you familiar with orders of federal courts to seal documents such as these?
Yes.
In this second meeting, what was Nate Paul and his lawyer's demeanor toward you and Mr. Penley?
I think that they were maybe not as gracious as they were during the first meeting. I think they understood by this point that...
Excuse me, Ranger. Object to what he thinks they understood. That's conjecture and speculation.
Sustained.
Well, what my answer is, my question is not what you thought they thought, but what was their demeanor. So what was their demeanor?
It was a little more animated than the first meeting.
Did anything happen at that meeting to change your initial assessment of whether this should be elevated to the level of an actual investigation?
No.
To clear that up, when you got this, did you start an investigation, as that term is understood?
Answer your question again.
Yes. Did you start an investigation? Did you initiate an official investigation?
No.
What do you do when you start an investigation?
When you start an investigation, you assign it to an investigator group. That is assigned an investigative number and it's put into the record.
And the reason that even after this second meeting, it had not risen to the level of investigation, what's that reason?
The reason was that the allegations had no merit and we weren't going to do the investigation if I had anything to say about it.
All right. Even though, and did you make that clear to not only now Mr. Paul and his lawyer, but also Mr. Penley?
Yes.
Even though that was your position, did you agree to submit their documents to your experts within the office?
Yes.
Okay. So was there a third meeting?
There was.
When was that third meeting?
It was on August 12th.
Was it clear to you by then what General Paxton wanted done?
Objection, conjecture, and speculation.
Was it, well, let me clear that up. Was it clear to you from what General Paxton told Mr. Mateer or Mr. Penley what General Paxton wanted done.
That's actually worse. That's hearsay and conjecture and speculation.
Actually, no, Your Honor, it's under 801E2D.
Counselor, you're going to make me look at these numbers, aren't you?
Yes, Your Honor.
He's just trying to throw you off.
801E2E says that a statement such as this is not hearsay, particularly
With respect.
when it is, excuse me,
I'm sorry, Dick, go ahead.
particularly when it was made by the party's agent or employee on a matter within the scope of that relationship. And here it's what General Paxton told to either Mateer or to Penley that was passed to the witness.
With respect.
That is not hearsay.
I'm sorry, Dick. With respect, Your Honor, there's a difference between what General Paxton said and what Ranger Maxwell can opine about General Paxton's state of mind. Those are two different things.
Not asking that.
You just did.
Sustained.
Well, let me ask it again then, if that's how it was understood. What message was passed to you by either Penley or Mateer that General Paxton had ordered done?
General Paxton wanted to have a third meeting.
I'm sorry. Objection. Objection, conjecture, and speculation. I have no problem with Ranger Maxwell testifying as to what General Paxton said, but there's a difference between what he said and what he wanted. I know it's splitting a hair, but objection, non-responsive.
Sustained.
What did he say he wanted?
He wanted us to tell Nate Paul that we were not going to be doing an investigation due to the results of our forensic analysis.
So going into that third meeting, is that what you believed it was going to be about?
Yes.
Was that meeting recorded like the first two?
No.
Who was responsible for it not being recorded?
General Paxton specifically told us that he did not want that meeting recorded.
Okay, so as you're going into a meeting in which you believe it's just for you to tell Nate Paul that you're not going to do his bidding, what happened?
The Nate Paul was there along with his lawyer, Michael Wynn. I had my two forensic experts, Mark Penley, myself, and General Paxton. My forensics people explained to Nate Paul the results of their forensic examination.
And very briefly, what was that result?
That the metadata that he was talking about that had changed could have been changed by the fact that there were documents he received had been electronically redacted and encrypted, which would change the metadata.
Is that a long way of saying there was nothing there?
Yes.
So, your understanding that General Paxton was telling you, tell him not that you're not going to have an investigation. What was General Paxton's? What did he say during that meeting?
During the meeting, he was supporting Nate Paul's position, which was that we need to do an investigation. And he was pretty adamant about it.
Was that meeting heated?
It became heated.
Who became heated?
Nate Paul.
Before that meeting started, were you aware of any public statements that Mr. Paul had made about whether there was an investigation?
Yes, I was.
And what were those public statements you were aware of?
He had done an interview with a business journal and told them that the Texas Attorney General was investigating the FBI and their handling of the search warrants again on his property.
Was that true or not?
That is false.
In fact, you had not started an investigation, correct?
We had not, and I specifically told Mr. Paul that we were not doing an investigation at this point, and our meetings were confidential.
And the response?
Oh, yeah, he responded.
What was his response?
He was very angry, and he said that he still has a First Amendment right. And I told him that all you're doing is using the power and the prestige of this office for your own purpose, and I'm not going to allow that.
Whose side in that dispute between you and Nate Paul did General Paxton take?
Nate Paul.
So, what was the significance of Nate Paul making a public statement that the Attorney General's office was investigating a federal magistrate and the federal authorities and the state authorities that the Attorney General was investigating? What's the significance of that kind of public statement?
Excuse me. Objection, conjecture, and speculation.
Sustained.
All right. Why did you think, what was your state of mind about why such a public statement, when it was not true about the Attorney General investigating these law enforcement people, what was your state of mind about why that was improper?
It was improper because Nate Paul was a criminal, and General Paxton was using the office to try to his benefit.
Can the very start of an investigation into a public figure be damaging to that public figure?
Yes, it can.
I'm sorry.
Is that?
Excuse me, Dick. Pardon me, Ranger. Objection, conjecture, and speculation.
Overruled.
You may answer.
Repeat the question.
Yes. Can the very public start of an investigation against a public figure be damaging, almost like a tattoo, to that public figure?
I got to object to leading in the tattoo. I'm sorry. Objection, leading.
Well, I'll reverse it. I'll take
Sustained.
the tattoo out of
Take
it.
the tattoo
Sustained.
If I take the tattoo out of it, may I ask the question again?
I just sustained that. You can try whatever you'd like to and see what he objects
Okay.
to or not.
Is there a danger to a public official's reputation by publicizing an investigation by the Attorney General, and especially when it's not true?
Yes, very much so.
Is that the reason you're very careful about having a criteria for starting an investigation?
Objection, leading.
Sustained.
What is the reason you're careful
We're
about
careful. We're careful because we don't want to put a stain on anyone's reputation. It has to be an investigation that is viable, has probable cause, and could move forward. This was not that.
All right. So let's talk about what happened after that meeting. Did you ever have any further conversations with Attorney General Paxton?
No, Attorney General Paxton stopped talking to me.
And your assessment at that time of whether General Paxton was angry with you?
Excuse me. Conjecture and speculation.
It's his state of mind.
Sustained. You can ask it differently if you'd like.
All right. Your state of mind after General Paxton and you left that meeting was what? About General Paxton?
Unless he said anything, conjecture and speculation. He's got nothing to base it on.
Overruled.
You may answer.
I know his state of mind because in the meeting he threatened to fire me. So I knew then what his commitment was to Nate Paul, and he was not going to be deterred from continuing to try and do things that benefit Nate Paul.
During this period of time with these 3 meetings, had you called upon any of your subordinates, any of your other investigators to, other than to look at this metadata, had you called on anyone to assist you in this review?
No.
Why not?
I told my people that this was going to get me fired. I was going to take the stand, and I was not going to jeopardize any of their careers by involving them.
Why did you think it was going to get you fired?
Excuse me.
He demonstrated his commitment to Nate Paul.
Witness, hold one moment. Your
State of mind.
objection?
Objection, conjecture, and speculation.
Overruled.
For his state of mind. Yes, you may answer.
He had already told me that if I conducted my business as the FBI does, that he was going to fire me. So I know that he was angry with me because I was not buying in to the big conspiracy theory that Nate Paul was having him believe.
And at this time, did you know that there was some action within the Attorney General's office to hire an outside counsel to do what you refused to do, and that is conduct an investigation into the federal authorities that were hounding Nate Paul?
I'm sorry.
Take out hounding, that were conducting their investigation on Nate Paul.
Objection vague. When is this time? I'm not sure where we are.
I'll clarify.
Sustain. Clarify, please.
At this time, we're now talking about the end after the 3rd meeting. Did you know that there was some movement for General Paxton to demand the hiring of a special counsel or an outside counsel? Did you know about it at that time?
No.
As far as you were concerned, was the Attorney General's office involvement in Nate Paul's complaints about how he'd been treated or mistreated, in his words, by the investigation into his activities? Was the Attorney General's office involvement over?
No, I didn't think it was, because I knew that he was probably going to fire me and hire somebody who would do it.
Excuse me. Objection, non-responsive. And conjecture and speculation. With all due respect to Ranger Maxwell, he's not the amazing Kreskin. He can't see everything in the future.
I'm asking for his state of mind.
Overruled.
You may answer.
Yes, I did not believe that General Paxton was going to stop pursuing this investigation.
Did you at that time, though, know about the hiring or attempted hiring of Brandon Kamak, the young lawyer from Houston?
No.
Did you find out about it later?
I did.
I want to jump ahead now to the very end of September and the beginning of October. Did you go on a vacation toward the end of September?
Yes.
And where'd you go?
We went to Colorado.
Did you learn, don't tell us what was said yet, but did you learn that there was a crisis of sorts among the deputies, your fellow deputies, in the Attorney General's office?
I did.
How did you learn it?
They contacted me.
And did you, even being in Colorado, they have phones up there last time I checked. Were you able to communicate with your fellow deputies?
I had to drive down the mountain to do it, but yes, I did communicate with them by phone.
What did you learn?
I learned that all the executive deputies, including Jeff Mateer, were going to stand shoulder to shoulder with me and confront General Paxton with what he has been doing to the agency for the benefit of Nate Paul.
What about a plan to go to the Federal Bureau of Investigation to report what they believed were, and what you believed, I believe, were crimes being committed?
Objection, leading.
What did you learn?
And again, what time frame are we talking about? Your question was late September.
Time frame is the end of September.
Sustain, re-ask.
Time frame is the end of September. In your conversations with your fellow deputies, what did you learn the plans were?
I learned that they were going to report the activities to the FBI. I learned that they had written a letter to General Paxton. I was not present, so I could not sign it. And I told them that I would also contact Lieutenant Colonel Randy Prince with the Texas Department of Public Safety and also tell him what was going on and that we were going to request an investigation.
So you knew Lieutenant Colonel Prince as a fellow Ranger, didn't you?
Yes, I broke him in.
And so by reporting to the Department of Public Safety, Lieutenant Colonel Prince, where was he in the hierarchy of the Department of Public Safety?
He is number 2, or he was number 2 in the department. He's now retired.
And at the time that you did that, were you making a report to law enforcement about General Paxton?
Yes.
What did you think would happen to you as a result of you reporting General Paxton to authorities?
Conjecture and speculation, Judge.
State of mind.
Judge, everything that doesn't get to come into evidence as state of mind.
Overruled.
You may answer.
I was going to be fired.
What happened on, I believe it was October 2nd, 2 days after the report? What happened on that date regarding you?
I received notification by text message from Greg Simpson, the division chief over human resources, notifying me that I was placed on investigative leave.
As a result of being placed on investigative leave, what did that do to your responsibilities in the Attorney General's office?
At that time, I had no responsibilities, had no access.
And how long did that situation last?
For 1 month.
What happened then?
On November 2nd, 2020, I met with Brent Webster, and he terminated me.
Stop you. Who was Brent Webster by that time?
Brent Webster was the new first assistant hired by General Paxton.
Would you describe for the Senate and the senators what happened when Brent Webster fired you on, did you say November the 2nd?
Yes.
Go ahead.
I was told to show up at 9 a.m. In the conference room next to Human Resources, and that I would be meeting with Brent Webster.
Were you still a law enforcement officer?
Yes.
Were you told anything about whether to bring a weapon or not?
My division chief over Criminal Investigation Division called me on the telephone when I was en route to the office, and he told me that Brent Webster said that I would not allowed to be in the building if I was armed.
So what happened after you went to this or showed up at the time you were supposed to show up?
I got there at before 9. I'm pretty much always early. And I waited till about 11:30 before Brent Webster showed up.
What happened then?
Brent Webster and Aaron Wrights came together, and they first asked me if I was recording this meeting, and I said no.
And you were not?
I was not.
Did you ask them?
I asked them if they were recording the meeting, and they said they were not.
And then what happened?
Then Brent Webster told me that he was conducting an investigation.
Did you believe that?
No.
And in fact, did his actions confirm your non-belief?
Yes.
What happened then?
So he attempted to interview me in a very vague and inept way, and I told him, just ask the question, I'll answer it, or I won't answer it. Just give me a direct question, and I'll give you what you want to know. We never got to the point where he asked me any really direct questions.
All right. How did it end?
He left, and he told me to be back at 1 o'clock. And so I went, had some lunch, and I came back to the office at 1 o'clock.
Did he show up?
No.
What happened?
Yeah, about 4:30, members of Human Resources showed up with my paperwork, and I signed the paperwork, and I was fired.
I want to talk just a moment about what I'll call retaliation. Were you retaliated against for what your actions that you took in this case?
Yes.
Tell the members of the Senate briefly how you were retaliated against.
That he retaliated against me, is what
Yes.
you're asking. Well, in firing me, at the time I was 71 years old and had risen to a top level of law enforcement. In effect, when he fired me and then berated me in the news, he ended my career.
By that time, your career had taken up how many years?
It was 48 years.
Were you proud of your career?
Absolutely.
What is an F5 form? That's an F as in Frank 5, the number.
It's a TCOL form.
TCOL means what?
Texas Commission on Law Enforcement.
What's the importance of TCOL?
TCOL is the regulatory agency for all peace officers in the state of Texas.
And so what happened at first with regard to your TCOL license and the F5 form?
The F5 form is a form that is required for the agency to fill out anytime they separate from a law enforcement officer. There are three things that you can mark on the F5. It can be an honorable discharge, it can be dishonorable, or it can be a general discharge.
Is a general discharge good or bad?
Bad.
Did you contest that?
I did.
Did you join in the filing of a whistleblower lawsuit? We call
I
it
did.
that. Why did you sue?
I sued because he ended my career in a very unjust manner.
Eventually, partly as a result of the lawsuit, was the general discharge reversed and you got an honorable discharge.
Yes.
Is that important?
Yes.
Why?
Because it's important to me to show that I had an honorable discharge and that I did nothing wrong by standing up for right.
We'll pass the witness.
Mr. Cogdell? Take as much time as you need.
Thank you. You good, Dick? Good afternoon, Ranger.
Good afternoon, Counselor.
How are you?
I'm good.
Good.
Mr. Condell, I'm sorry, since you're a little taller, you're going to need to get closer to that microphone so we can
Wait, I'm
or
taller
raise
than
that
Dick?
up. There you
Good.
go.
All right. It's been a minute, has it not?
I confess,
Sir?
I confess, he is taller. And in fact, well,
It's been a minute since you and I have seen each other.
It has.
Let me go into sort of your preparation for this hearing. And Ranger, I know you as Ranger Dave Maxwell, so I'm going to call you that whether you want it or not because it's just in my brain.
I'm good with that.
That good. What have you done in preparation for testifying here today, Ranger Maxwell?
I've consulted with the attorneys. I've reviewed the material that has been turned over that I would be speaking about.
And is your lawyer here?
Yes,
Tell me his name.
T.J. Turner.
And he's in the room.
He is.
Now, when you say that you have consulted the material, let me make sure I'm on the same page with you.
Okay.
I'm aware, Ranger Maxwell, that there are transcripts of your original meeting with the Board of Managers back in February. You've read that transcript, I assume?
Yes.
There is the July 21st, 2020 interview by you of Mr. Wynn and Mr. Paul, right?
Yes.
I assume you've read that transcript?
I have.
There is the August 5th, 2020 interview by you and Mark Penley of Mr. Wynn and Mr. Paul, correct?
Yes.
There are also videotapes. I think the first one is about an hour. The July one and the second one is an hour and a half or so.
Hour and 17 minutes, an hour and 54 minutes.
Your memory is not lacking. I'll give you that, at least so far. But have you seen the videos as well, Ranger?
No.
Okay. Well, I may ask you some specific questions about those meetings. So let me give you copies of the transcript, Ranger, just so if I get down in the weeds and you need them, you'll have them, okay?
Yeah, it's good.
May I approach, Your Honor?
Yes, you may.
Ranger, the Board of Managers,
Okay.
the July and the August.
Okay. Good.
He was not on mic, but he was simply pointing out to the witness what the different folders were.
Let's go back to, I guess, your first involvement, Ranger, with this particular investigation in terms of your testifying, okay?
Okay.
And by what I mean by that is when you were interviewed back in February, I think, by Therese Buse and Dan McAnulty.
Yes,
You remember that interview?
I do.
You've read it.
I have.
And in reviewing that transcript, Ranger, in your review, did you see anything that was in error or a mistake?
I see some things that may be misconstrued
What are those things?
about Drew Wicker and what he may or may not be able to testify.
Gotcha. Now, let me put you on pause there. You weren't here, obviously, during the opening statements, so you don't know what was said or what wasn't said about Drew Wicker and your statements about Drew Wicker. You weren't here, right?
No, that's correct.
Have you met with Mr. DeGuerin or anybody from the Board of Managers team in anticipation of your testifying?
Yes.
Who did you meet with?
I met with Mr. DeGuerin, Rusty Harden, met with the other attorneys that are helping prosecute this case.
Okay. And was that topic brought up in the meeting? That is what you said in the February meeting about Drew Wicker?
Yes, they did ask me about that.
Okay. Now, you know Mr. DeGuerin personally,
Yes.
and to jump way back in time, which was one of the first times I met you, Mr. DeGuerin famously walked into the Branch Davidian compound during the siege in 1993.
93.
Were you escorting him in and out? Was that you?
No, I did not.
But the Rangers did have a significant role in the investigation of that that incident, that tragedy, whatever we want to call it, right?
Yes, I was one of the lead investigators.
Yes, sir. And if my memory serves me, Ranger, correct me if I'm wrong, but I think you helped a much younger me get access to my client in that ordeal. Did you not?
I did.
Thank you, sir. Now, I mean this sincerely and respectfully, Ranger. You're an icon with the Texas Rangers, right?
I don't see myself that way.
Well, a lot of folks do. You'd agree with me?
I've heard a lot of people say that, yes.
You are in the Texas Ranger Hall of Fame, right?
Well, at some point.
What do you mean at some point? You are now.
I am not an official member of the ones they recognize as being in the Hall of Fame. My picture has been there. There was once an exhibit on me in the Hall of Fame.
Well, let's see. You joined the DPS in 1972.
That's correct.
You became a Ranger in 1986.
Yes.
You left the DPS, and I'm sure 95% of the people in the room know this, but some folks watching on TV may not. All of the Texas Rangers, the genesis of being a Ranger, you hail from the Department of Public Safety. That's the outfit through which you become a Texas Ranger, right?
Yes, because the Rangers are a part of the Texas Department of Public Safety.
Yes, sir. So all told, with the DPS and the Rangers, your career lasted 38 years?
38 years.
Now, you made some statements to Mr. DeGuerin about how ludicrous it was to be investigating judges or assistant United States attorneys in this particular case, right?
Yes, in this particular case.
Yes, sir.
That's correct.
But certainly you would agree with me, Ranger, that in your experience, you have been part of investigations, even prosecutions of assistant United States attorneys or judges, right?
I have investigated and prosecuted public officials. I've never investigated a senior federal magistrate or an AUSA.
Well, let's go back to the Waco incident. One of the fallouts, tragically for one of the assistant United States attorneys in that case, a fellow who I actually respect a lot, so I'm not going to mention his name, but I think you know who I'm talking about.
I do.
He was charged with a federal offense after that ordeal, was he not?
He was.
Now, you mentioned OIG, which is the Office of Inspector General, right?
Yes.
And they are kind of like, I don't know what you'd call them, OPR or what is it in local law enforcement when you have a complaint against a law enforcement officer? Help me with the verbiage.
I don't think we on the state level have an equal to the Office of Inspector General because they cover all of the federal agencies as far as being able to inspect them. We don't have that in Texas. We don't have oversight of other agencies.
Okay, fair enough. But would you agree with me that in your experience as a Texas Ranger, you've seen, wrongful prosecutions of DPS agents?
Yes.
One of those was a fellow by the name of Sergeant Bob Nestoroff. Remember that?
I do remember Bob, yes.
He was I think, head of DPS narcotics enforcement.
He and I were in narcotics at the same time.
And he was charged by an AUSA in Florida, if I remember, for perjury and obstruction.
He was.
Came here and went to trial in Houston in front of Lee Rosenthal, right?
Yes.
You remember his lawyer, right?
I don't remember who his lawyer was, no.
Objection for a moment, Your Honor. Relevance.
Well, my point is this. No one...
Relevance.
Overrule. Let him continue.
Well, let's just say his lawyer looked like a 27-year younger version of me, but that's not really the point. The point is even AUSAs can make mistakes, right?
You're talking about one individual.
Yes, sir. Yeah. One individual that charged a compatriot of yours for something he didn't do.
Yes.
Okay. My point is, it is not beyond the realm of possibility for anyone, including an assistant United States attorney, to make an error in judgment or whatever that ends up being criminal. Agree with me? It's rare, but it happens.
It's rare, but it happens.
Now, let's talk about the resources through your 38-year career, Ranger, that you've been exposed to. You would agree with me as a general rule that you have seen the tools and the resources available to law enforcement grow exponentially in your time.
Absolutely.
There are kinds of investigative tools that weren't around when you started with the DPS or when I started practicing law that are around today. You agree with me?
There's no comparison.
Yes, sir. Things like Crime Star.
Yes.
Things like CLEAR for law enforcement, it's public records database, right?
Yes.
Accurate for law enforcement, again, another public records database, right?
Yes.
TLO by TransUnion, another law enforcement public records database, right?
Yes.
Cellbrite, a cell phone analytics tool, right?
Say that again.
Cellebrite, it's a cell phone analytics tool. Gray Key, another cell phone analytics tool.
Yes.
PenLink, another phone analysis tool.
Yes.
Obviously, TCIC, NCIC searches, right?
Yes.
Criminal history checks, driver's license checks, right?
Yes.
Access to some utility companies' databases, right?
Yes.
Open source data like YouTube, Facebook, Twitter, X, all those sorts of things.
Yes.
And 95% of that just wasn't around when you started your career, right?
Absolutely.
So you would agree with me, I think, Ranger, that if you don't know how to use those tools, you could certainly find somebody that could help you use some of those tools if you wanted to use them. Agree with me?
Agreed.
Now, the DPS and the Rangers have all kinds of teams at their disposal, right?
Yes.
They have a reconnaissance team, agreed?
Yes.
A special response team, agreed?
Yes.
A public corruption unit team, agreed?
Yes.
It is not unusual at all for DPS or the Rangers to participate in internal investigations, right?
That's correct.
DPS from time to time, I am told, triple hearsay, uses hypnosis.
We used to. I think it's been phased out now.
Did you yourself?
No, I didn't want.
You never did?
I didn't want to do that.
Your legend has been diminished by just a bit. I thought you used hypnosis. All right.
No, sir.
Now, you yourself, Ranger, you have taught all kinds of courses, right?
Yes.
You personally taught on how to conduct investigations.
Yes.
Agree? You have taught on interrogation techniques.
Yes.
Agree? You have taught on how to testify in court.
How to what?
Really? You just did that? Come on. You have taught on how to testify in court.
Yes.
And no disrespect to anyone, this is not your first rodeo. You have testified a few times, right?
That's correct.
Can you estimate for us, Ranger, how many times you have testified in courts across this state or across this country?
Hundreds.
Okay. Now, simply put, Ranger David Maxwell knows how to conduct an investigation if he wants to, right?
Yes, that's correct.
And you have literally conducted probably thousands of investigations?
Yes, thousands of investigations.
I guess, Ranger, anything from traffic tickets to capital murders and everything in between you've investigated, right?
Yes.
Now, let's talk for a minute about the good traits of an investigator. See if we can agree on a few good basics. One, they should have the training and the mental tenacity to be a good investigator, right?
Say that again.
They got to be smart enough to know what they're doing.
Yes.
They should have an open and objective mind.
Yes.
They should go into an investigation without bias or predisposition.
Yes,
They should be willing to follow the evidence.
that's correct.
And they shouldn't make assumptions that aren't based on sufficient evidence, right?
Yes,
Now, it is also important, is it not, to follow up on any leads or information given to them by others?
I lost some of that. Say it again.
And I couldn't help but notice you've got a hearing aid.
I do, and so it's a little hard for me.
Yes, sir. And if I don't speak up enough, please
All right.
let me know.
Thank you.
It's important for a good investigator to follow up on any leads or information that's been given to them, right?
Yes,
Would you agree with me, Ranger, that a good investigator understands that, you know, we're kind of all equal under the eyes of the law in terms of everybody's entitled to have an investigation, at least if it's warranted by the facts, investigated, right?
yes,
An inmate or a president or anything in between. Agree with me? An investigation should be thorough
yes,
and accurate records and reports should be generated and maintained.
yes,
And that's important not only for the investigator that's involved in the case, but really for the future of the case, right?
yes,
I mean, investigators leave, they get fired, they quit, but the case may still be going on, right?
that's correct.
So once again, you have the experience, the training, the assets, the knowledge, and the relationships and the contacts to do a great investigation if you were inclined to do that, right?
Yes, I do.
All right, let me ask you, and I think Mr. DeGuerin touched on it briefly, but let me do it as well. I think he mentioned a search warrant and a probable cause affidavit, right?
Yes, he did.
Where is I have just a minute, Your Honor. Affidavit itself. Right. Well, while he's looking for what he should have had, Eric, while he's looking for that, let me cover a couple of things with you, Ranger. First off, the quantum of proof that a search warrant must satisfy before a judge or a magistrate signs off on it is probable cause, right?
Yes,
And the lower standard of proof is scintilla, and then we go into probable cause, then we go into clear and convincing, and then we go proof beyond a reasonable doubt. You're aware of all those things,
Yes.
right? Now, thank you. I'm going to show you, Ranger, I don't know that if you have seen this or not, but I'm going to show you, without offering it for obvious reasons, the underlying affidavit in support of the search warrant for Mr. Paul's properties and the search warrant itself, okay?
okay.
May I approach, Your Honor?
Yes, you may.
Good for right now. Sure. I'll need some later, though.
Yes, let me know.
All right.
So what you have in one hand is a search warrant, which is pretty thick, right, Ranger?
Yes.
You should have, and if you'll pull forward, Ranger, because we got to have your voice. Pull forward.
sorry.
That's all right.
All right.
You should have two different things. One is a part of the other, but one is the greater search warrant, which is several inches thick, right? The entire search warrant.
Yes.
And then included in that, which we've excerpted out, is the search warrant affidavit or the affidavit in support of the search warrant, right?
Okay.
Now, you have prepared, estimate for us, Ranger, how many search warrant affidavits?
I couldn't tell you. I mean, it's a lot.
A lot, like thousands.
Yeah, it's a lot.
Now, you would agree with me that the content that goes into a search warrant affidavit is meant to do really one thing and one thing only. And that content that is to go into a search warrant affidavit is to convince a magistrate judge that there is probable cause for the issuance of a search warrant to search a given premises or a given location at a given time, right?
Yes.
And what's important is not the personalities of the judge or anything to do with the prosecutor or anything to do with anything other than what information would establish probable cause, right?
That's correct.
Now,
Excuse me, objection. And I object to any further reference to this affidavit as it was not part of his review and he's not seen it before.
I'm happy for the ranger to take a few minutes to look at it, but these are, Dick, I think they're going to be pretty global questions. But if the ranger needs time to look at it, I'm happy to stand down for a few minutes.
And we also object to relevance.
The relevance is what Mr. Hardin has suggested time and time again about how the search warrant affidavit could endanger the lives of judges and prosecutors and all this. I'm going there. I'll show you the relevance.
I'll overrule the objection, but Ranger, do you need some time? Would you like 5 or 10 minutes to look at it? It's a good time to break. Members, be back at 2:45.
Thanks, sir. Good to see you.
may resume.
Thank you. Ranger Maxwell, I asked you, sort of gave you a hint at the break of where I'm going on this document, so let's go there. Back up just a second. We're talking about the search warrant affidavit in the Nate Paul case, but really the questions kind of apply affidavits, generally speaking, not just here, okay?
Right.
Would you agree with me, Mr. Ranger, that in your training in terms of law enforcement, that you are trained that if charges are filed, that ultimately the defendant who is charged will get a copy of the search warrant affidavit?
That's correct.
And the basis for that, to bore us all a little bit, is whether the search warrant affidavit is sufficient or not is often argued by defense lawyers as a basis for trying to suppress the search, an illegal search. That's the typical argument, right?
Yes, correct.
So anybody that fills out a search warrant with any experience is going to know at some point this could well end up in the hands of the defendant or his lawyer. Agree with me?
Yes.
So as a habit, custom, and practice, Ranger, it's true, is it not, that you would not put anything in a search warrant affidavit or really allow anything to be put in a search warrant affidavit that could come back to haunt somebody from a personal safety perspective, right?
That would not be my first choice, but sometimes judges don't give you a choice.
Well, certainly there have to be names, right?
They'd have to be named, yeah.
But they don't have home addresses of the cooperator or where their kids go to school, or that just doesn't happen. Agree with me?
That's correct.
All right, now, this particular search warrant, I'm assuming you've never seen this particular search warrant or the affidavit in support of the search warrant before. This is the first time, I think, you've seen this?
It is.
And did Nate Paul ever indicate to you in any of your meetings with him that he had a copy of the affidavit of the search warrant?
He told me very directly and positively that he knew who signed the affidavit for the search warrant.
That he what?
He knew who was the officer who signed the search warrant on the probable cause affidavit.
He knew who signed it?
He knew who signed it, yes.
Yeah, okay, all right.
Who the affiant was.
Sir?
Who the affiant
Yes,
was.
And who the affiant was is often discoverable on the search warrant itself, right? Not the affidavit, but sometimes it's on the affidavit and the warrant. Agree with me?
Maybe, but he referred to the probable cause affidavit.
Okay. The affiant is the person who signs off on
That's correct, yeah.
So what he told you, if I'm understanding you right, Ranger, is that he knew who the affiant was, right?
That's correct.
He did not say, I have a copy of the search warrant affidavit. Rather, he said, I know who the affiant is. Right?
Yes, he did.
Okay. Now, let's get to the matter at hand a little more directly. You received the referral from the Travis County DA's office on, I think, June 10th of 2020. I think Mr. DeGuerin showed you that in your direct.
Well, it was created on June 10th. It went through regular mail, so I didn't get it on June 10th.
Okay. You got it within a few days.
So I got it through the mail.
Okay. But you had gotten an email from Don Clemmer telling you that the referral was on its way, right?
Yes.
And I think that is the point in time where you did what a Ranger Dave Maxwell would do. You Googled around and figured out, at least in your worldview, this guy is up to no good. I don't want anything to do with him, right?
Yes.
And you really began the investigation believing that Nate Paul was a criminal, right?
Not just because of what you said. I felt he was a criminal because of all that I saw.
Fair enough. But my point is, when you began your review, I'm not going to say investigation because it never got that far, okay? So I don't want to step on your verbiage.
Right.
But when you began your review, you began it with the conclusion that this guy is a, quote, criminal and you want nothing to do with it, right?
When I began the review, my thought process was I wanted to see what it was that he had to say.
We'll get there.
And that was what I told my boss, Jeff Mateer, that I would take a look at it. And when I read it, the allegations of conspiracy among so many professionals
let me slow you down just a little bit, Ranger, because we're going to get there. But will you agree with me, at least right here, that you didn't exactly go into those meetings with a positive mindset about Mr. Paul, right?
No.
Okay. Now, if I'm understanding it right, the Travis County DA's office decides it's not the appropriate agency to review or investigate this complaint because the Travis County DA's office deals regularly with DPS and with the Rangers, right?
That's not exactly true.
That's part of it.
That's what was in the email, but that's not exactly the case.
Okay, but that's at least what's in the email. You'll give me that part.
That's correct.
Now, does it strike you as ironic at all, Ranger, that they say, we're not going to investigate this because we're too close to the Rangers or to the DPS, and yet they refer it to a Ranger that's in the Hall of Fame that had a 40 plus or minus year career with the DPS? That doesn't strike you as ironic?
I can explain that answer if you like.
Well, first answer my question, and I'll let you explain it. I'll give you that much, Ranger.
No, it doesn't strike me as ironic.
Okay, doesn't sound like Mickey Mantle investigating the Yankees?
Say it again, please.
It doesn't sound like Mickey Mantle investigating the Yankees?
I'm sorry, I still couldn't understand you.
I'm sorry, and I don't know if it's the microphones or what.
All right, really good.
I'm trying to be cute, but I'm really trying to make a point.
Okay.
It's kind of like Mickey Mantle investigating the Yankees.
Okay.
Doesn't exactly jump off the page as an objective review. That's my point.
I would say you talked about my professionalism. I always look at things objectively.
And let me stop you, Ranger. At no time, sir, I may disagree with what you did or didn't do, but at no time am I going to suggest to you that I think you're a liar or you're unprofessional or you're not a man of great character. That ain't where I'm going.
Okay.
We good?
I'm good.
All right. So it was Clemmer that you had the conversation with, Don Clemmer, Ranger?
I did.
And I think you knew him from back in the day at the Harris County DA's office?
Actually, I knew him when he worked for the AG's office because he was the executive deputy over prosecution when I was there in the law enforcement division.
Gotcha.
So we were colleagues at that point.
You were also friendly with him, I guess?
Yes.
So there's nothing in your personal history that would be a source of conflict or tension between you two?
No.
So when you called, when was this first call? Was the call between the time you got the email and you got the referral?
No, I called him after I got the referral in the mail.
Okay. And did you express to Don at any time, Ranger, Mr. Clemmer that is, did you, Ranger Maxwell, express to Don Clemmer, you know, I'm probably not the right guy to investigate this. I don't like Nate Paul. I don't trust him. I think he's a criminal. I think the world of the Rangers. Did anything like that come up in that conversation?
No, my language was much stronger than that.
Okay, but you communicated those thoughts.
I communicated my thoughts in unequivocal terms.
And four-letter words were involved, I'm imagining, Ranger?
I probably won't use the same language in the court that I'd used at that day.
I wouldn't ask you to, certainly. There may be some court somewhere, but this is not the one I'll ask you to use the language in. All right, so it is true, is it not, Ranger Maxwell, that typically as the, are you deputy director? Are you director of law enforcement? Give me your title again at the...
Director of law enforcement.
Okay. Typically as the director of law enforcement, Ranger Maxwell, you didn't often get personally involved in investigations, right?
Yes, I oversee them, and sometimes I actually personally get involved.
But that's my point. The majority of the time you oversee.
Yes, absolutely.
Okay. And you certainly would you typically, Ranger, assign something like this if a player like Nate Paul wasn't involved? Would you typically assign a referral like this to someone lower than you on the food chain?
I would assign it to my major who was over special investigations and have him sign a team to investigate the allegations.
And I think you told us the reason why you didn't assign it anyplace else, but regardless, you kept this one for yourself, right?
I did.
All right. Now, you got the referral in mid-June, right?
Yes.
And you had the first meeting with Nate Paul and Mr. Wynn, Michael Wynn, July 21st.
That's
right?
correct.
Now, let's set the stage in terms of, forget about how your thoughts about Nate Paul, forget about your thoughts about Paxton's involvement with him, and focus, if you can, on just the otherwise oddity of having a conversation with a fella who is under investigation for federal offenses, right?
Yes.
And he comes in to you, a known quantity, shall we say, in the law enforcement community, and he and his lawyer are sitting down with you, opening themselves up to asking them any question you want to, right?
That's correct.
I'm going to go out on a limb here, Ranger, and suggest that despite your storied career, something like this may not have ever happened. Would you agree with me?
Possibly.
Okay. Now, and when I say something like this never happened, let's just say I don't know many defense lawyers that would have taken the same position as Michael Wynn and walked their client into that meeting. Agree with me?
Okay.
Now, before that meeting started, did Ken Paxton ever come up to you, did General Paxton, Ranger, ever come up to you and say, hey, I want you to give him immunity. You can't use those statements against him. He gets a free pass for anything he says. I mean, there was no condition put on your being able to ask Nate Paul questions. Agree with me?
That's correct.
And likewise from Mr. Wynn. He never likewise asked you, hey, everything is off the record here. You're not going to go anywhere. That didn't happen either.
No.
In fact, I think you told, was it Mateer, that, yeah, I'll have this meeting, and what I'm going to do is if they say anything that incriminates them, I'm going to mail it right over to the U.S. Attorney's Office, right?
Well, no, I was going to contact the FBI and give that information to them. I also told General Paxton the same thing.
Okay. So the point is you went into it with the mindset that if Nate Paul, or I guess even his lawyer, said anything that was incriminating about any criminal activity, that you were going to pass that information on to the appropriate agency.
Yes.
Right? And it's true, is it not, Ranger, that never happened. That is, they never said anything that incriminated them or that you passed on to another agency, right?
Right.
I want to make sure, I don't know, frankly, Mr. President, I want to offer, if it's not in the House Board of Managers Exhibit 149, which is the video of the 721 interview, as well as the Board of Managers 151, which is the transcript of that same interview.
No objection.
Okay. And likewise, while I'm doing that, I want to offer into evidence 156 and 158, which are the video of the August 5th interview that Ranger Maxwell and Mr. Penley had of Mr. Paul and Mr. Wynn, as well as the transcript, which is 158.
Okay, let me.
No objection.
We're looking at those numbers.
I'm looking at.
Yes. Yes, Mr. DeGuerin?
Oh, no objection to the introduction of those, of the video, audio, and transcript.
Thank you.
Make sure I have the numbers right. Hold on, Counselor.
Yes, sir.
We're going to enter 151, 149, 156, and 158 into evidence.
Yes, sir.
No objection. Show them being entered into evidence. Go ahead.
All right. Now, Ranger, do you still have the three little,
I do.
and and I'm not going to try to give you a pop quiz and ask you if every single word that I'm saying I hope you'll trust me far enough to say if I say it, it's in there. But if you want to check me, please check me and I'll point you to the citation, okay? I think early on in your House interview, which is also in front of you, I think that's the orange folder, that you said his main allegation, when you were, to back up, when you were being interviewed, I jumped from your interview of him to their interview of you, but in your interview with the Board of Managers, you said his main allegation of why he didn't like the raid that they conducted was he was alleging that the copy of the search warrant had been altered, right?
Right.
And that's true, right?
Right.
That's true in terms of that was what Nate Paul was claiming to you, right?
Right.
And that at some point in the first interview, I think Nate Paul told you, Ranger, that he didn't even think they had a search warrant for at least one of the properties being searched, which was the storage unit. You recall him telling me that?
Yes.
And he went way deep. That is, Nate Paul went way deep into metadata, right?
Yes, he did.
Do you know as little about metadata as I do?
Maybe less.
All right. Metadata, at least as far as you and I know, is sort of the fingerprints that any electronically created documents leave.
Yes.
Now, you said that, and I hear you, you said a couple of times to Mr. DeGuerin that his accusations were so ridiculous and so conspiratorial, I'm characterizing, that it was just absurd to you to even hear him, right?
Right.
Would you agree with me, Ranger, that Mr. Wynn, his lawyer, through both of those things, did say words to the effect, Ranger, that he doesn't think they're evil people, maybe they just relied upon poor information and they don't know how to back out? You remember that verbiage that Mr. Wynn?
No.
If you will look, Ranger, on page 63, line 22 of the 712 interview, and for the color-coded challenge, that is going to be in the green.
In the green, he's looking in the orange right now. The green or the...
Yeah, David, Ranger.
Ranger?
Look, the 712, which should be in the green folder.
Yeah, on the green folder.
Yes.
I'm sorry, 721. If you'll look on page 63.
63, okay.
At the very bottom of 63, you recall Mr. Wynn telling you, I'll wait for you to get there, Ranger.
Okay.
At the bottom of 63, Ranger, Mr. Wynn says, that's the problem. I don't think they're evil people from the core. You see that?
Well, mine doesn't have all the words.
Yours doesn't have all the words?
It says, that's the problem. I don't think they're, and it's blank.
Well, the next line is, I don't think they're evil people from the core. You see that?
Right.
And make sure you keep that microphone close to you, Ranger.
Sorry.
No, sir, that's fine. And then the next page, it says at the top of page 64, Ranger, they listened to the wrong people and it got it wrong and they just can't come forward and say, oops, right?
That's what he said.
Now, again, not suggesting that you should buy that description, but that is certainly what Mr. Wynn is telling you in this first meeting, right?
Yes, that's right.
Okay. Now, you told Ranger this jury in no uncertain terms that you never had any intention of ever investigating this. It was nonsense from the beginning, and you just wanted nothing to do with it. Again, I'm paraphrasing what you told us, right?
That's correct.
Ranger, it's true, though, that you never said that to Mr. Wynn and Mr. Paul.
That's correct.
Okay. Instead, what you told them, and this is probably the sly investigator coming out in you, I don't mean to diminish your skill set, but what you told them was, maybe I can get some answers for you, right?
Right.
And you said, I can look at this and talk to the DA's office and see where we get, right?
Right.
Told them, I'll look at the metadata just to see what our people tell me about it, because I pay a lot of money to those people to get them trained, meaning your metadata people.
That's correct.
Right?
Yes.
And I will sit down with the DA, and if we have something, we do. And if we don't, and they say no, that's as far as I can go, right?
Right.
So, and again, I think I get the reason why, but what you're telling us about your opinions about their story or their position is certainly different than what you were telling them, right?
Say that last part.
Yes, sir. What you're telling us, your opinion of their description of what may have happened, your opinion that you shared with us is a very different opinion than what you shared with them. That is Mr. Paulins. Okay.
Absolutely.
Now, did you, though, early on, Ranger, tell them that it was up to the DA's office, ultimately, to accept charges or not?
Yes.
Okay. So when Mr. DeGuerin said, had the DA's office recused themselves, and that's a term of art we'll probably get to, but when he said, have they recused themselves, you said yes, but you certainly never told or suggested that to Mr. Paul or Mr. Wynn, that is, that the Travis County DA's office had recused itself, right?
I go back to the protocol I testified in the first place, which is I require.
Ranger, I can't hear you. And I don't mean to step on you, but I want to hear you.
I go back to my first statement when we talked about the protocols I have in place, that I require a letter from the DA in that jurisdiction that he'll either prosecute or recuse himself and let us prosecute.
Okay. And correct me if I'm wrong, but I don't think you ever got a letter from the DA in this case that they had recused themselves. Margaret Moore never wrote you a letter and said, we are recusing ourselves from this investigation.
There is no investigation at this point.
Okay.
There was not going to be an investigation, and there's nothing for them to review.
Okay. I hear you. But if they didn't recuse themselves from an investigation because there was no investigation, they didn't recuse themselves from anything.
No, not the investigation. They had to if they wanted to recuse themselves and have us prosecute.
Yes, sir.
They either have to agree to prosecute the case or recuse themselves and allow our people to prosecute.
And neither one of those things happened, if I'm understanding what you're saying right now.
Neither one were going to happen, no.
Gotcha. And that's my point.
Yeah.
That didn't happen. And maybe you know this and maybe you don't, but I'll go out on a limb and ask you. Do you know sort of the conditioned precedent for a prosecutor pro tem? Do you know what that term means? And you may not, Ranger.
No, I'm not going to try and define that.
Sir?
I won't try and define that.
Fair enough. Now, what is the web pass system? The web pass system.
I'm not sure.
Well, as I understood it, and I could be wrong, law enforcement division maintains what is called a web pass system, which has an offense report or a case file in it.
I'm still not understanding what that is.
Well,
What's the purpose of it?
let me just put it this way. You never created any memorandum, right?
No.
No memorandum of an interview, right?
No.
No report of an investigation or a review.
That's correct.
No note to the file, right? You didn't initiate so much as a post-it note, if I'm understanding you right. I'm sorry if you can't hear me. I think you're the only one in the world that can't hear me right now, Ranger. But you didn't even create a post-it note about this case.
I did not take any notes or even create a post-it note about it. That's correct.
Now, Operation Longhorn. May I have just a minute? I approach Mr. Guerin. I think I showed you this.
Yes, you may.
I've seen what he's offering, Your Honor, and my objection is that it's not only if it's offered for the truth of the matter, we think it's false and we don't want it, so we object to it. But I don't know what the offer is.
Well, I thought at the break that he had told me he wasn't going to object to it. Whatever, that's fine.
Go to your mic so we can all hear the conversation.
From my understanding with Mr. Guerin at the break, he told me he wasn't going to object to it. But that's all right. People can change their mind, Dick. I've been married a few times. It's okay.
Mr. Guerin?
Let me clarify that. I told him I didn't object to it, but I don't agree that it should be admitted for the truth of the matters stated. It's something that was prepared by Nate Paul and his lawyers to show to Mr. Maxwell. We think it's hogwash, but it can be admitted.
Is that an objection, Dick?
Yes, that's an objection.
Objection hogwash?
Objection hogwash.
All right. You best not sustain
Wait a
that one,
minute.
Your Honor.
Which one of those rules is that one, Mr. Guerin? 802 or 803? Got them all up here.
803.75.
If it's not, we're writing a new one. Okay.
It is not, Mr. President, being offered for the truth of the matter asserted, but only to show that Ranger Maxwell and I think Mr. Penley actually were presented with a copy of this. We're not suggesting it's true or it's the letter of the law, but only that it was given to them. That's the limited scope of the offer, all right?
We'll overrule.
All right,
We'll overrule. Because it's not being offered as truth as the matter asserted.
Mr. Arroyo, are you with me? And it's marked, I don't think I said this for the record, Your Honor, it's AG 1005. So we're offering AG 1005. And Ranger, can you see that screen in front of you?
Yes, we're up on screen.
Thank you.
This is your exhibit?
Yes, sir. It's the electronic copy of what I'm holding in my hand, Judge.
For the same ruling, we'll admit this into evidence.
Yes, sir. All right. Mr. Arroyo, could you go to the first page? Next page. Yep, next page, please, Eric. And if you could highlight the first sentence for me, please, and blow it up.
Can you go back to the microphone, please?
Oh, I'm sorry.
Sure.
It's a big room. If you could blow that up for us, Eric. It says that there were 3 search warrants that were executed simultaneously on Wednesday, August 14th. You see that, Ranger?
I do.
And if we'll go down, Eric, to the second to last paragraph, it says, since the search warrants were sent as PDF files via email, after the searches, we were able to analyze the metadata of the PDF documents that were emailed, right?
I see that.
And finally, Ranger, it says, according to the filings with the court in the Western District of Texas, each of these search warrants was signed and issued by Judge Mark Lane on Monday, 10 a.m., August 12th. But if we look at the first sentence and the last sentence, what they are alleging is that the search warrants were, per the filings, per what you and I could see if we looked at them, the search warrants would have been issued at 10 a.m., but on Monday the 12th, but in reality, the documents were created on Wednesday the 14th, 2 days later, right? That's their claim.
No, what it says is that the 3 search warrants that were executed simultaneously on 9 a.m. on Wednesday, August 14th.
I got you. And the filings say, you're right, I stand corrected. They were executed on
the 14th,
right? And then on the next page, Eric, if we'll go to the next page, and I think that were there a total of 6 warrants, Ranger?
Well, there were 3 warrants that are executed. They had 3 more warrants that they did not execute.
Gotcha. So you spent a long time listening to Mr. Paul's description and Mr. Wynn's description of this Contigo, this search of a storage facility. You spent probably 30, 45 minutes listening to that. And the net of their suggestion to you, Ranger, was that the search warrants for that facility were created after the search, right?
That's what they're alleging.
Okay. And according to them, and again, I don't know metadata, but according to them, Ranger, it was through the forensic analysis of a PDF that was sent by Alan Bowie to one of their prior lawyers, Chuck Meadows and Aaron Borden. That's how they say they broke the code on this. You with me?
I am.
And you agree with that summary?
What's that?
You agree with the summary that that's their claim? I'm not asking you to
That's
believe
the claim.
fact. That's their claim. If we go to the next page, and again, they are saying that the document metadata reveals information that is inconsistent with looking at the documents on their face. You with me?
Mm-hmm. I am.
Okay. And I'm not going to bore us all, but this is what they gave you back on August 5th, right?
I see it.
And they also gave you a thumb drive, correct?
Yes.
Now, I think one of the things that would be a condition precedent was whether or not a condition precedent for involvement by the Attorney General's office of the state of Texas would be a violation of state law, right?
Okay, yes.
I mean, you can't investigate, investigate, or prosecute federal cases, right?
That's correct.
Will you at least agree with me that if what they were saying was true, that these actions by federal prosecutors would be a violation, if they were true, a violation of state law, right?
The state law, and this is one of the only reasons why I agreed to hear him out, was falsifying a government document would cover a federal document.
Yes, sir.
Even though we don't have jurisdiction over anything else about it.
Gotcha. And I think we're saying the same things, you probably better than me, but if a federal law enforcement agent or prosecutor or judge or whatever, if they knowingly entered false information into a document with the intent to deceive someone else, not only would that be a federal crime, it would be a state crime. I think it would be tampering with governmental records, right?
That's correct.
Now, would you agree with me, Ranger, that despite your concern or belief or hope that Mr. Wynn or Mr. Paul would say something incriminating or say something that would cause them exposure criminally, neither Mr. Wynn nor Mr. Paul ever ask you to do anything illegal?
Yes, they asked me to interfere with a federal investigation, which is absolutely illegal. It's also obstruction of justice.
Show me, Ranger, in the first hour or the second 2 hours on the investigation or the interview of July 21st or August 5th. You've got the transcript there for both of those.
Counselor, you are showing me the evidence right here. This is it's a map of how he wanted the investigation to be done and to have the AG's office follow how this was to be investigated, along with targeting 6 individuals.
Okay, where does he, excuse me, Ranger.
Go through it and you'll see it.
Show me.
It'll show it. I don't have a copy of it.
I'm sorry?
I don't have a copy of it.
You do. You've got a copy of the entire transcript of July 12th, Ranger?
No, I'm talking about the document you have up on screen right now.
Show me, Ranger, where they say you reviewed the transcripts of the July 12th interview and you have reviewed the transcripts of the August 5th interview. Show me the language where in either one of those interviews, Ranger, that they ask you to commit a crime.
They're not in the interviews, Counselor. They are in the document you're looking at right now. He lists 6 people as a person of interest to be targeted in this investigation.
Where does
right
it
here. It's in Operation Longhorn.
I'm sorry, I'm talking over you. I apologize, Ranger. Where in this PowerPoint, show me, Ranger, where in this PowerPoint that Mr. Wynn asked you to commit a crime or Mr. Paul asked you to commit a crime? Where?
Objection, Your Honor. He doesn't have a copy of this in front of him. May I give him my copy so he can answer that question?
Providing a copy now.
No, I don't.
My apologies. I thought you had one.
Your Honor, may we approach about some
Yes, you may.
addresses?
Yes, you may.
Judge, can we get a minute? Can we get a minute so they can do what they need to do with the world famous Eric?
We are going to let Eric go to work here.
Yes, sir.
We'll take a stretch break for 5 minutes, stand at ease. Members, just to let you know, we are redacting some personal information from a file, and that's what we're taking some time to do here. Exhibit 1005. Members, if you can retake your seats. Eric has resolved the issue, and I know I've mentioned his name a few times. Stacy, I just want to be sure we appreciate all of your work too. Okay. Yes. I think they both have a page out there.
All right. We
Ready to
good?
resume.
We good, Ranger?
Yes.
All right. So what happened there is that someone noticed that there were names and home numbers or home addresses and telephone numbers. We've redacted those names, right?
Yes.
Now, what crime is Mr. Wynn or Mr. Paul asking you to commit by tendering this PowerPoint to you?
They entered the PowerPoint and gave it to us to map out how they felt our investigation that they wanted to be created should go.
Okay. We have a transcript, do we not, of exactly what they said?
Transcript of?
Exactly what they said when they were meeting with you on August 5th when they gave you this PowerPoint?
Yes.
Okay. And you've reviewed that transcript, you say?
Yes.
And where in the transcript, what words do they use to describe to you that they desire a crime to be committed?
They obviously did not say that they wanted a crime to be committed. What they wanted was an investigation.
Okay. And your position, Ranger, is two private citizens coming in and asking for an investigation into whether or not search warrants were illegally created, that asking for that investigation is a crime?
Following through on the investigation is a crime.
What crime would it be to investigate the legality? If that's a crime, I'm going to be on death row. I investigate the legality of search warrants all the time. That's what I do. What crime is it, Ranger, for them to ask you to investigate the legality of a search warrant?
The only purpose...
No, sir. Objection non-responsive. What crime is committed?
Sustained.
Objection, he didn't allow him to finish so we could see whether it's responsive or not. I believe it was going to be responsive. Objection to interrupting the witness.
I'll
Overruled, sustained, but
I'll ask again. And I'll
ask again, take a pause.
And I'll calm down.
And you can raise the mic too.
And I'll calm down and raise up. Okay. I'll try again, Ranger.
Right.
Even at my age, I get excited every now and then. What crime is committed, Ranger, by them asking you to investigate the legality of a search warrant? What crime is that?
In my professional opinion, to create this investigation and follow through it would be obstruction of justice and interfering with a federal investigation.
Okay. In fact, doesn't Mr. Wynn say over and over and over in the transcript he does not want to interfere with the federal investigation? He does not want to obstruct justice? Doesn't he say that?
He does.
Okay, so the fact that he's saying he doesn't want that done, even though he says he doesn't want that done, you think it's a crime because?
His actions belie his words.
Okay. Well, you are Dave Maxwell, Hall of Fame Ranger. If they would have committed that offense right there, literally on videotape, the Dave Maxwell I know would have stuffed and cuffed him right there. You would have arrested him, right?
No.
Okay. All right. In fact, Ranger, what did you tell him?
I told them that what I said in the beginning, that we would have the forensic people look at the metadata, and they promised to give us all the documents they had in order for us to do an examination.
Let me try again, Ranger. Instead of saying, you've committed a crime, I'm going to arrest you, what you say on page 143, line 24, is we're going to look every which way into this, right?
That is exactly right as far as the metadata.
Okay. You said, Mr. Penley says, quote, we're going to look into these allegations, right?
He may have said that.
Okay. Mr. Penley says, thank y'all for coming in today. We appreciate it. Thank you for the handout and for the documents. We'll look into this.